Right. All right. I appreciate everyone's patience. So apparently WebEx did an update today, and I didn't realize that until I clicked on it to start the meeting. And but I appreciate everybody's time. Becky, I appreciate you taking on the general meeting. So I think it's safe to say we're done with all the general meeting items.
Yes.
Okay. All right. So without further ado, we will go ahead and get started on our regular meeting. All right, so my name is Katie Byrne. I am the Executive Director of the BMZA. Earlier, if you were following along in the general meeting, Becky Witt is the attorney for the board. What faces that you'll see on the screen are our zoning members. Mr. Bill Cunningham is a member. Mr. Leland Shelton is a member. Mr. Otis Freeman is a member. Ms. Sabrina Turner is a member, and Mr. James Fields, also on your screen, is our chair.
Well,
So
my name is, but my face won't be.
All right, so his name is
have
there, but his
video.
face will not be. Boy, we're just having great technical days today, aren't we?
Thanks.
So if you've signed in via the internet, you're considered an attendee. So right now, you do not have the ability to turn your camera on or to unmute yourself, okay? So what happens is that at the bottom of the screen, however, you'll see a microphone, camera buttons, and a chat feature. Once your case is called, I will make you a panelist and unmute yourself, and you will be able to turn your camera on if your camera is functional, and we will be able to see you. Attendees who call in and wish to testify will hear 2 beeps when they are unmuted. If after you hear the 2 beeps, you wish to speak on the issue, please speak right away. If not, I will move on to the next caller. If you're unable to connect to video, please use the chat feature. If a speaker is inaudible, we'll ask you to call back and try again. There are 2 ways you can testify in support or opposition of a matter. First is using the chat feature. You can put your message in the chat, identify the case number, and whether you support or oppose. We ask that you please do not use the Q&A because I can only look at one feature at a time, and chat is the better feature. Also, there is a hand raising function. So you can raise your hand and let me know if you wish to testify once that matter is called. And I would encourage everybody, if when you're done, please lower your hand. If you have any issues with WebEx, clearly I did today, right? And you cannot, for whatever reason, get in, please call our office. We'll make sure that we can give you the phone number if you can call in and participate as a caller. Our number is 410-396-4301. If you are having additional technical difficulties, cannot participate for whatever reason, you may email a motion for reconsideration explaining your difficulties and what you would have testified to at bmza@baltimorecity.gov. All right, so without further ado, I'll turn it over to the chair. And did you guys go through the docket already in the general meeting?
We did.
Yes.
Okay, excellent.
Katie, can you hear me?
I can.
All right. I'm going to try to keep my voice up. I'm told that I'm having some additional technical difficulties with my audio. So I'll try to just keep my voice up and just wave or let me know if you can't hear me at times. So welcome, everyone. We will hear cases today with the intent to decide your matter at the end of the docket, unless we advise you that we need additional information or there may be some other reason for which we can't render a decision in the deliberation portion. But generally, you should receive a decision on your matter within 30 days. If you would like, you may feel free to contact the BMZA office to the decision, 410-396-4301. Again, 410-396-4301. But we ask that you not undertake any work on your project until you do have a decision from the BMZA, and certainly don't do any work within Baltimore City without pulling the proper permits. Today we have an extensive consent docket. We have several matters that are on the regular docket, and we have at least one matter which will be postponed today. Matter is case number 2021 343. That's 808 South Ann Street. Uh, uh, there's a history to that one and various briefings that are filed. And so the board needs some time to review those matters. And Katie, I didn't tell you that, but we did
Right.
that in the original.
I see that. I also see we have a message in the chat, and I see Miss Hecker has raised her hand. The message she had put in the chat would be to suggest when it could be scheduled and additional papers, and set a date by which additional papers and evidence must be submitted so they don't have the same issue the next time. We
Sure.
can put this on the very next docket. So if the board would like to put a deadline for additional filings by other parties. So the next docket is March 22nd.
Yeah, I would, since we have the last pleading, I guess, that was filed, memoranda by Ms. Hecker, was filed yesterday or yesterday evening. I would say if we could get any additional papers within the next week.
So then the deadline for submittals for anything on this
Yeah.
From either party needs to be submitted by the 15th.
Be good, so that we have a week to, again, digest all that additional material that's already before us, and we'll be ready to go on the 20th.
Okay, so we'll reschedule this for the 22nd, and all parties must submit any documentation they wish the board to consider by the 15th.
All right, fair enough. All
Okay.
right.
Hey, James, I could use
Yes,
your
sir.
fine segment.
Okay, good, thanks. I'll try to keep that up. So we will commence the consent docket, and for those who are unfamiliar, the consent docket involves those matters for which the board believes it has sufficient information to approve the appeal. And so we call the case, we hear any reports that we have from the planning department, through Mr. French, and from staff that through Ms. Byrne, and then we will resolve that case. And then we will turn our attention to the regular docket. I think 4 or 5 matters on the regular docket. No further ado. Hopefully, we won't have any more technical difficulties. So let's just get started and call the docket. First case on the consent docket, case number 2021-282, 921 North Crescent Street. The appellant is Robin Horry, and this matter addresses variances necessary to construct a 2-story rear addition. Now, here in the reports we have from planning and staff.
Thank you. Martin French for the Baltimore City Planning Department. The Planning Department has no comment on this application.
As Mr. Field stated, it's to construct an addition for a first and second floor of an existing semi-detached dwelling in an R4 district. The variances requested are as follows: minimum rear yard setback, 25-foot setback is required, 21 foot is proposed, so a 4-foot variance is requested. Minimum interior side yard setback, non-party wall, 15 feet is required, 9 feet 8 inches is proposed, so it's a 5-foot 4-inch variance request. Maximum lot coverage, 35% is required, 81% is proposed, so it's a 46% variance to lot coverage. And I will look for Ms. Horry. All right, so I do not see Robin Horry here listed. If you are here as the applicant for, it looks like we have the 2 Crescent Street properties, 921 North Crescent and 923 North Crescent. Please. Oh, okay, just got a chat. He's not in, he just emailed me. He's having technical difficulties, gonna try to join by phone. So what I'm gonna do right now is go through the call-in users. So as I go through the call-in users, if you are here for 921 and or 923 North Crescent, please speak up. If not, we might have to come back to both of these. So again, once you hear the 2 beeps, if you're here for those 2 matters, please speak up. If not, I will move on to the next call-in user. Okay, moving to the next caller. 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 And now the last caller. Okay, he is not joined by phone yet. So,
All right, well, we can move on.
all right, so it's gonna be those two, both 921 and 923 North Crescent. We'll have to recall.
Okay, moving on, we're calling case number 2021-313, 2623 through 2627 Washington Boulevard. The appellant is PFSL Holding Corp. The request to use the portion known as 2629 Washington Boulevard as a restaurant, adding live entertainment and dancing. I'll hear from planning and staff.
Department of Planning has no comment on this application. Thank you.
So this is a conditional use for live entertainment and dancing at 2629 Washington Boulevard. Currently is a restaurant. There are special considerations in the code for live entertainment and dancing, and the board may limit the types of live entertainment and dancing to which it's used and allowed, and impose any conditions appropriate concerning to hours of operation, operations in general, types of live entertainment or dancing, amplification, noise levels, limits on size of establishment, configuration of the live entertainment, dancing and venue, number of entertainers, number of seats, if there's proposed for outdoor dining, exterior lighting, whether to limit the use of live entertainment only or dancing, any kind of public need or desire for this kind of establishment, location, number of other establishments in the area, the potential effect on those, the proximity to residential dwellings, educational facilities, places of worship, parks or playground, maximum authorized occupant load for the particular location, volumes and types of vehicular and pedestrian traffic, and potentially could establish and the maintenance of traffic management, parking management, indoor outdoor security plan, and a sanitation plan. So all of those things are in play for when the board considers a conditional use for live entertainment and dancing. All right, so again, if you are here for 2021-313, 2623 to 2627 Washington Boulevard, please raise your hand or put in the chat that you are here as the applicant, because I only have the corporate name listed. There we go, Mr. Sinclair. I'm going to try to elevate you as a panelist. All right, so I can't elevate you as a panelist, but I'm going to unmute you because of how you're calling in. So Mr. Sinclair, are you here for 2021-313, 2623 Washington Boulevard?
Yes, ma'am.
Okay.
All right, Mr. Sinclair, is there anything you'd like to add to your application at this time, sir?
I'm just a resident, and I live in the area directly behind the restaurant, just down on the street by Parksley. And so I was just
Can I
looking
interrupt you one moment, Mr. Sinclair? Are you
Oh, yes.
not the applicant?
Oh, no, ma'am. I'm sorry. No.
Okay, all right. Are you in support or in opposition? Because that'll help us figure out when we recall you.
Opposition.
Okay. All right then. Hold on one moment, Mr. Sinclair. I'm going to mute you.
Okay.
All right. So I do have the applicant here, Harry Previs. I'm going to elevate him as a panelist, and then James, if considering we have opposition.
Well, we've got him on the phone, so let's
All right.
deal with
Let's
them.
go ahead. All right. So Mr. Previs, making you a panelist. All right, Mr. Previs, you're unmuted.
Good afternoon, Mr. Chairman, members of the board, and good afternoon, Katie. Let me start
Good
the
afternoon, Mr.
video.
Rivas. Yeah, you were originally on the consent docket, sir, but we learned that there is some opposition, so we're going to go ahead and ask you to tell us about your case, and then we'll hear from the opposition subsequently. Okay.
Okay.
Thank you.
I'm here with Mr. Heber Ruiz, and he is the applicant. And if I may proceed by proffer, Mr. Ruiz will limit in this live entertainment request, he's looking for mostly karaoke and DJ. He would limit the hours of that to 9 p.m. to 1 a.m. He had approval from the Morrill Park Community Association. He spoke with Wendy Roberts and they gave it the okay. And he currently employs around 6 people, and his current hours are 11 a.m. to 11 p.m. He primarily serves Central American food, and the karaoke and DJ would be of Central American variety as well, as a benefit to his customers. He's operated this restaurant since May of 2017. And as to parking, is it correct that you have parking behind your restaurant?
Front and behind, yes.
And where is the nearest residential
It would be
house?
across these woods from the back of my restaurant.
In your estimate, how far away would the nearest house be?
I'll say a couple 100 feet.
Could you guys hear that? He said a couple 100 feet.
Yes.
And are there any churches and schools near your restaurant?
Not too near.
Okay.
There'll be a few blocks over.
Okay, he said a few blocks over. And we have nothing further.
Okay, so your current hours of operation for the restaurant are 11 to 11. And through the use of this live entertainment, you want to extend the hours to 1 a.m.? My system just froze. Can you guys hear me?
Yes, that's correct.
Did you hear my question?
Yes, it's correct. We want to extend
Okay.
hours to 1 a.m.
Would that be every day or the weekends, for example, Friday, Saturday?
It'll be mainly Friday, Saturday, Sunday, but when there's like sporting events like football season, we want to do Monday and Thursdays.
All right. Any members of the board have any questions for
Do we have, or did you submit a letter of support from Morrill Park? Because I don't see anything.
I don't think so, but we have talked to them and ran the idea by them, and they gave it, when we spoke to them, that they gave us the okay.
did they give the okay for those hours that you referenced today?
Yeah, Wendy Roberts said she was going to submit a letter. I don't know if, I guess you didn't receive that, but I did speak with her yesterday.
Okay. And my question is, did you tell her about the hours that you're seeking to have the restaurant open for the live entertainment till 1 a.m.?
No, we didn't speak about that. We just spoke about controlling the noise and the parking situation.
All right. Well, you would agree that that might be of some relevance to their agreement if they know how long and how late you plan to go, right?
Yeah.
Okay. Are there any other community associations that your property location, covers or is a part of the area, the geographical area?
That I know of is just a Morrill Park community.
Correct me if I don't have your application in front of me. Are the hours for which you're seeking to extend or have this live entertainment, are the hours stated in that application? And the number of the days and the hours?
Yes, they are. In question 15 of the application, section 15, it's 2 a.m. Friday, 2 a.m. Sunday, 2 a.m. Saturday, but they would, Mr. Ruiz is more than willing to limit the hours.
And the question then becomes to what? So you've stated 1 a.m. On your application, you had Friday, Saturday, Sunday to 2 a.m. I recognize your desire now to extend it to days of the week that have maybe sporting events. Sounds like football season, Monday and Thursday. What are you willing to limit your hours and days to?
Well, the weekends, Friday, Saturday, Sunday, and Monday and Thursday.
And this is just for the record, so we're clear about what it is you're asking. Friday, Saturday, and Sunday till 1, which is what you represented here today, or 2, as represented in the application,
Well, till 1 a.m.
right? And Mondays and Thursdays, those sporting events sometimes go a little late, but I don't think they go till 1 or 2. Are you willing to limit them to any earlier hours on Mondays and Thursdays?
Yeah, I think by
Well,
12. I think that Dan by 12 a.m.
So you're seeking Monday and Thursday at 12 a.m.
Hey, James,
Yeah,
this whole thing sounds a little loosey-goosey to me, given the fact that we don't have anything from the neighborhood association.
well, it's not the norm. I mean, we typically, if we have some agreement or okay from neighborhood association, we'd like to get that written and documentary evidence of that, which is by way of a letter or a memo or something that comes to us. And it is a little concerning that you told them they were okay with it, but you didn't tell them what the hours would be, which is a critical issue in these kinds of variances that you're seeking. Does any other board member have any concerns or feelings about that concern that Bill just raised?
I agree with Bill.
So here's a possible suggestion, Mr. Prius. Would you all be willing to go and secure that support in writing from Morel Park? Confirming their understanding of the hours that you're seeking, the days and the hours that you're seeking, and that way we know for sure. With nobody here from Morel Park, we, can't be sure what they understand. We could give you time to do that. You could come back on our next docket to present that information.
Yeah, we can do that.
All right. So,
And I would suggest Mr. Sinclair is also on the line. He was in
Yeah.
opposition. That you reach out to him as well.
Absolutely.
yeah, and I guess you can exchange information through Ms. Burns' office or however you want to do it. But yeah, we'll seek to. Katie, have room on the next docket for this?
We're tight, but I think we'll be okay.
Okay.
So we'll go ahead and
All
put you on the March 22nd.
Okay.
Right. Well, I appreciate that. Again, I think for your sake and for the sake of your application, it would be helpful, for the board to have that additional information and support in the record, before we deliberate.
Okay. Thank you very much.
Thank you. So, case number 2021-313 is postponed to be reset, another date.
We can go ahead and put it on the 322 docket. And Mr. Previous, if you can have your client change the date on his sign, keep the sign up and change it to 3/22.
Okay, thank you.
And I've asked Mr. Previs for his contact information, and I'll share that with you. I mean, Mr. Previs, Mr. Sinclair.
Okay, thank you
I
very
read
much.
Previs.
Thank you. We'll see you back.
All right.
All right, and we're gonna move on to case number 2021, that's 321, 3401 Minnesota Avenue. Clarence Askins is the appellant, and this is a request to use portion of the existing church known as my system involuntarily muted me. We'll say this is a request to use a portion of the existing church known as 3400 Brems Lane as a community center. And I'll hear from planning and staff.
Thank you. Planning Department has reviewed this application and believes this property is adequate for the purpose and has no objection to the application.
Thank you.
Conditional use again for community center. It's to use the portion of the existing church and daycare at 3400 Brems Lane. It's in an R7 district. The applicant may need to return for a parking variance. Community centers require 1 space per 10 persons based on the fire rated capacity. So until the applicant knows what their occupancy is based on what they have as far as parking goes. So I'm just putting that out there. So I will call Clarence Askins, and before Robin Horry for the 2 Crescent Street properties is now on as an attendee. So if you want, we can call them after this one.
Will do.
Clarence Askins, there we go. Clarence, I've just made you a panelist.
Okay.
And you are unmuted.
Good afternoon, Mr. Askins.
Good afternoon. How you doing?
I'm doing well, sir. Thank you. Sir, is there anything you'd like to add to your application at this time?
As far as the parking is concerned, the church does already have adequate parking. We have a parking lot. It's on the other side of Minnesota. I do not have the exact information for it, but we do have a parking lot that you could approximately put definitely at least 50 cars on that parking lot. We also have permission to share a parking lot with Howe Funeral Home, who is across the street. So I will also be speaking with him again for not just on Sundays or for church events, but during the week as well.
Okay. Well, very well. Thank you for that additional information. We'll make that part of the record. The board having heard your appeal, we believe we have sufficient information to approve your appeal. Thank you very much, sir.
Thank you.
All right. Good luck to you.
Thank you.
All right. We'll include Minnesota Avenue. So let's turn our attention back to Katie. I'll call them both. Case numbers 2021-282, which is 921 North Crescent Street, with Mr. Horry as the appellant, and case number 2021-283, 923 North Crescent. Again, Robin Horry is the appellant. Both of these matters address variances necessary to construct 2-story rear additions on those locations. And I'll ask you, Mr. French, for any reports from planning on 282 and 283.
Thank you. Planning Department has reviewed both applications and has no comment on either one.
Thank you.
Katie, you're muted.
Thank you, I appreciate that. So 2021-282, 921 North Crescent Street. The variance is to request a first and second floor addition on an existing semi-detached dwelling. In minimum rear yard setback, 25 feet is required, 21 feet is proposed, 4-foot variance requested. Minimum interior side yard setback, non-party wall, 15 feet is required, 9 feet 8 inches proposed, 5 feet 4 inches requested. Maximum lot coverage variance, 35%, 81% is proposed, 46% variance needed. For the next property, which is 923 North Crescent, again, existing semi-detached dwelling, same thing, first and second floor addition. The variances requested are identical. So 25-foot rear yard setback required, 21-foot proposed, 4-foot variance requested. Minimum interior side yard setback, non-party wall, 15 feet required, 9 feet 8 inches proposed, 5 feet 4 inch requested. Maximum lot coverage variance, 35% required, 81% proposed, 46% variance of lot coverage. Robin Horry, you are unmuted.
Yes, ma'am. Can you hear me?
Sure can. Mr. Hurry, let me take 921 North Crescent Street first. Is there anything you'd like to add to your application at this time?
Oh, he's muted again. All right, try again, sir.
Can you try? Can you hear me?
We can
Yes.
hear you. Can you hear us?
Vaguely. Can you repeat, please?
Yeah, the question is with regard to the first property, 921 North Crescent Street. Is there anything you'd like to add to your application at this time?
No, sir.
All right. With regard to the second property, 923 North Crescent Street, is there anything you'd like to add to that application at this time?
No, sir.
All right. Well, then the board, having heard your appeals, we believe we have sufficient information to approve your appeal for both 921 North Crescent Street and 923 North Crescent Street. Okay?
Thank you very much.
Thank you, sir. Have a good day.
Would I be receiving a note?
You will be receiving a formal ruling from the BMZA.
Have a good day. Thank you so much.
Thank you. Right. Jump over to case number 2021-341, 124 Marketplace. The appellant is Dish Wireless and Paul Whitley. The request, or this appeal addresses a request to attach 6 antennas, 3 proposed and 3 future, to existing building with related ancillary equipment and cabling routed to steel platform to support equipment cabinets. I'll hear any reports from planning and staff.
Thank you. Planning Department has reviewed this application. This is the first in a few years we've had for this type of installation or reinstallation of wireless communication facilities. The department is recommending approval of this application with these conditions. The antennas and related equipment, as visible from the street, must be painted to match the building to ensure they are visually unobtrusive. Antennas and related equipment will remain mounted as illustrated in the plans and elevations approved by the Planning Department. The applicant will adequately mitigate any adverse effect as specified in the report of the Historical and Architectural Preservation Division of the Department of Planning in accordance with that report's recommendations. Thank you.
Thank you, Mr. French.
As Mr. French stated and as Mr. Fields, it's to attach 6 antennas, 3 proposed, 3 future to existing building with related ancillary equipment and cable routed to steel platform to support equipment cabinets. So this is a conditional use, so the board would need to apply its conditional use standard for our wireless communication services at 124 Marketplace. I've got Mr. Paul Whitley here, and he's now unmuted.
Dish Wireless can comply with all those conditions.
Great. You just anticipated my first question, Mr. Whitley. Thank you for that. And is there anything else you'd like to add to the application today, sir?
No, unless you have any questions.
No questions here. I can tell you that the board, having heard your appeal, believe we have sufficient information to approve your appeal, subject to those conditions that were stated on the record. Thanks so
Thank you.
much. Right. Moving on, case number 2021-342, 4114 Montana Avenue. Janetta Thomas is the appellant, and this is a request to install a fence 6 feet in height, portion of which will be located along Benton Heights Avenue. Hearing the reports from planning and staff.
Planning Department has no comment on this application. Thank you.
So the variance required for the installation of the 6-foot high fence along Banton Heights Avenue, it's a corner side yard setback, 20 feet is required, 0 is proposed. So it's the full 20-foot variance requested to install the fence. And I've got Ms. Thomas. I'm going to make her a panelist. And Ms. Thomas, you're unmuted, ma'am.
Good afternoon. My name is Janetta Thomas. My appeal number is 2021-342. And I have no, nothing against what they're saying.
Okay, and so nothing to add to your application at this time, right, ma'am?
No, no, sir.
Okay, thank you very much. Ms. Thomas, the board having heard your appeal, we believe we have sufficient information to approve your appeal. Thank you so much.
Okay, thank you so much.
All right, have a great day, ma'am.
You too. Bye-bye.
Calling case number 2021-345, 2127 St. Paul Street. AB Associates is the appellant. This appeal addresses the variances to bulk regulations related to the use of the entire premises as a multifamily dwelling with 5 dwelling units. The variance is required for off-street parking. Hear from planning and staff.
Thank you. Planning Department has no comment on this application, but does note that this application in a different form was previously approved by the board on the basis of appeal number 2016-312, heard October 20th of 2016.
So
Thank you, Mr.
this is variance to bulk regulations to use the entire premises in a multifamily dwelling with 5 units, and the variance is required for off-street parking as well. So 2 variances. First, a lot area variance, 5,250 square feet are required. 2,460 square feet proposed, so that's a 2,790 square foot variance requested. Off-street parking, 5 spaces are required, 4 spaces are proposed, so it's a 1-space parking variance that's being requested. And I see Mr. Barry is here as the applicant, and he usually, I don't see him, but he usually calls in, so I'm gonna go through the call-in users. Oh, okay, they're here online, so it's Michael Castagnola is here, so I will go down to him. There we go. All right. Okay, I've made you a panelist and you are unmuted.
Hey, how you doing? This is Michael Castagnola and Al Barry. I just want to introduce myself to the board. Thank you for your consistent help moving along our applications. I am taking over for Nate Predel, working with Al, so we will be seeing each other on an ongoing basis.
Awesome. Well, welcome, sir.
Thank you. We have no particular commentary on this application. This is a resubmission from an application that expired in the past that had already passed. We are just reapplying to get it moving again.
Very well. The board having heard your appeal, Mr. again, Castagnola.
Good, thank you.
Awesome. The board having heard your appeal, we believe you have sufficient information to approve your appeal.
Thank you.
Thank you so much, and look forward to working with you going forward.
Looking forward to it. Thank you.
Okay. Thank you, Mr. Barry. Okay, that will resolve that matter. And moving on, case number 2021-347, 1639 Belt Street. Michael Story is the appellant. And this matter addresses variances to bulk regulations related to the construction of a 2-story rear addition, rear deck, and a rooftop deck. I'll hear any reports from planning and staff.
Thank you. Planning Department has no comment on this application.
Conditionally, variance requested for the construction of the 2-story rear addition and deck and rooftop deck. Maximum lot coverage, 60% is the maximum, 87% is proposed, so it's a 27% variance requested. Rear yard setback, 20 feet is required, 10 feet is proposed, so it's a 10-foot variance requested. I'll elevate Mr. Story to a panelist. And Mr. Story, you're unmuted.
Hi, thank you for hearing my case today. My name is Michael Story. I currently own 2-bedroom, 1-bath, single-family home with a rear deck and patio located in the Riverside neighborhood. In order to increase the space's functionality, I plan to expand the rear of the house to add in a master bathroom and this on the 2nd floor, as well as a half bathroom on the main floor off the kitchen. My residence will maintain its use as a single-family home. And as part of this expansion, I plan to repurpose the existing patio as a parking pad and with an overhead deck leading to a rooftop deck. The addition of off-street parking will facilitate the reduction of the street congestion in the neighborhood. And this design for this renovation was inspired by conglomeration of neighboring homes, an attempt to maintain the look and functionality of the alleyway and the neighborhood.
Awesome. Thank you, Mr. Story, for that additional information. And happily, we can tell you that the board, having heard your appeal, we believe we have sufficient information to approve your appeal.
Excellent. Thank you.
Right. Have a great day.
You too.
Right. Moving on, case number 2021-348, east side of South Haven Street and O'Donnell Street. The appellant is Carolyn Hecker. This appeal seeks to subdivide the parcel in 4 separate parcels, with the northernmost parcel to be redeveloped as an outdoor recreation facility with accessory restaurant with no off-street parking provided. Now hear from planning and staff.
Thank you. Planning Department has been working with the applicant on this one for a number of months. The application is proposing a use which the Planning Department is fully supportive of, which is an outdoor recreation facility, which will also be conveniently located next to a recreational trail being developed in that portion of Baltimore City. The one concern that the Planning Department has and has expressed to the applicant, and we discussed it at great length, is about the issue of safety for people using this facility to and from their vehicles if they park off street. Because this is on Haven Street, which is a major designated truck route in East Baltimore. And the applicant is going to continue to work with the city's departments of planning and Department of Transportation to resolve these issues, to find a way basically to make it as safe as possible for the patrons of the facility to traverse Haven Street safely to and from their games and other outdoor recreation. The department is recommending approval of this application be subject to the condition that approval of the site plan for the proposed use is obtained from the Site Plan Review Committee, and that a plan for safe access by patrons of the proposed use to and from their off-street parking area is approved by the Departments of Transportation and Planning. Thank you.
Thank you, Mr. French.
Hey, Martin, is the city council bill in this, has it been submitted already?
It has. So we have city council bill for rezoning the property from I2 to C3. It was enacted February 22nd, 2022. So it's the rezoning has occurred.
Thank you.
And just to piggyback on what Mr. French said, basically we have 2 requests here: conditional use as recreation and outdoor, and then a variance to off-street parking. So 38 spaces are required, 0 proposed, so it's a 38 space variance requested. And Ms. Hecker is here and unmuted.
Good afternoon. Caroline Hecker, Rosenberg, Martin Greenberg on behalf of the applicant. I can respond briefly to Mr. French's comments. We have been working very closely with the planning department to develop a plan that that works well for the community and that has very safe pedestrian access, recognizing the proximity to the Haven Street truck route. I am pleased to report that we have arrived at a solution with DOT this past week for how to handle pedestrian crossing across Haven Street. And we are incorporating those plans into the site plan that we'll be submitting next week to the Site Plan Review Committee for review and hopefully approval. So we are making sure that it is handled in a very safe manner, recognizing the proximity of the truck route. But we do think it is a great use for the neighborhood, and there should be a letter of support in your file from the Brewers Hill neighbors.
Excellent. Thank you for that additional information, Ms. Hecker. The board, having heard your appeal, we believe we have sufficient information to approve your appeal. Thank you so much.
And Ms. Hecker, before you leave, this is something we didn't discuss earlier. So for Ann Street, if you could have your client change the sign for 322 today, so that we make sure that it's posted, that it's on the next docket.
We will do it.
Thank you.
Thank
you
you.
Much. Case number 2021-351, 301 East 24th Street. The appellant is Nefertiti Amen Rock, and this is a request to use the premises as a child care center. I'll hear from planning and staff.
Planning Department has no comment on this application at this time.
Thank you, sir.
So this would be a conditional use for a child care center in a C1 commercial district. So again, it's just conditional use standard based on the zoning and the location. I do not see Nefertiti Amen-Ra here on our list. If you are in the list here for this particular property as the applicant for 2021 351 301 East 24th Street. Please either raise your hand. Oh, wait, here we go. Have one. All right, thank you. Amran Akram, I'm making you a panelist now. And you are unmuted.
Hi, how you doing? My name is Imran. I'm the property owner.
Welcome, sir.
Thank you.
So this is seeking to use the premises as a child care center. Do you have a number of children that you're seeking to serve at this location?
So that's certainly the intention, right? Nefertiti's business is providing healthcare and services, educational services to the children in the neighborhood. I purchased the property a few years ago and built it out for the sake of trying to find a use for it for the kids in the neighborhood. You know, as we all are aware that, you know, providing services to children, especially educational, is kind of paramount. So I'm willing to do whatever it takes to make sure that that happens.
Okay. Let me just ask you, Ms. Byrne, I suppose we have all the information that we need sufficient for approval as a child care center without those other particulars.
We do, it's in a C1 zone. A lot of times the childcare centers that you guys get to review and approve are in residential zones. So we have issues relating to drop off, pick up, parking.
Sure.
But since this is in a C1 zone, it's slightly different. And I would ask Ms. Witt, is there anything in the application that jumped out that that the board needs to be aware of?
Not to me, no. I don't have anything to add.
Okay, yeah, but given the fact that it's in C1, not in a residential zone, it doesn't necessarily present the same kind of challenges that the board usually sees when someone's trying to create a daycare.
All right, very well. Sir, the board having heard this appeal, we believe we have sufficient information to approve the appeal. Thank you so much.
Thank you.
Okay, case number 2021-352, 2411 Tawny Road. Could be Taney, but I'm going to call it Tawny. AB Associates is the appellant. And this is a request to construct a one-story addition that will consist of an extension of the kitchen and master bedroom bathroom suite. I'll hear any reports from planning and staff.
Has no
we have
comment on this application. Thank you.
Okay, the request is it's one variance request, interior side yard setback, 10 feet is required, 8 feet is proposed. So it's a 2-foot variance requested.
Okay. And we have Mr. Casagnola again.
Yep.
With AB Associates.
True. Thank you for hearing our case. We
Sure.
have the neighbors were spoken to, and I'm unconcerned about this addition. It's a minor variance in the corner of the yard. The owners are looking forward to increasing their space and comfort at their house. We have no further commentary about this appeal.
Very well. The board having heard your appeal, you believe you have sufficient information to approve your appeal. Thanks so much.
Thank you.
Thank you.
All right, regular docket. So it looks like, Katie, I'm jumping through the last matter. The last
Yes,
intent.
that's
Okay.
what I see too on the docket.
Case number 2022-125
On the consent docket.
on the consent docket, correct.
Right.
Case number 2022-125,
Correct.
2703 through 2709 Foster Avenue. Michael Burton is the appellant. And this is a request to construct a 2-story with ground floor level garage building to be used for a multifamily dwelling. I'll hear from Penny and staff.
Mr. French might not have a report on this. So this didn't make it on our actual docket on the website. This is something that we agreed to move quickly and put on the docket for Mr. Burton. This is his second go round with this particular property before the board. He made some changes to the site plan, I believe to square footage for units that impacted his variance requesting for parking. So, and Mr. Burton, I've obviously made you a panelist and you are unmuted. So as I want you to affirm.
Yeah.
I want you to affirm exactly what I'm saying so that you get the relief, like the relief that you're asking for is before the board. So what I have is you're requesting relief to off-street parking, interior side yard setback, and bicycle parking.
No, I met with the community last night, so there's gonna be a clarification of that. It's actually
Okay.
even easier.
All right, so then tell us exactly what you're
Okay.
asking the board to
So
do.
exactly what it'll be is we have 28 units. We have 4 that are less than 500 square feet. So that's gonna make it that we have a reduction of 2. So we're gonna request a
Reduction of 2 what?
2 parking spaces
Okay.
for that. And then we're gonna request a variance for a reduction of 4 parking spaces to have a total of 22 car parking spaces. Bicycle parking will not be affecting any of the parking issues at all. They will not be taking place for parking spaces. They're just not part of any of the variants. It's just, we will provide 22 parking spaces and we will need a technical variance of a reduction of 4 parking spaces. That's that issue. And we met with the community last night and showed a plan where we could find 2 additional parking spaces to make that work. Because the request to you, we couldn't figure that out. Working with them, we did figure that out, and we have 2 additional spaces to make it so we have 22. Moreover, we've been to site plan review and committee. It hasn't been signed off, but we've been through site plan review committee, and we will be providing 2 additional parking spaces for the community out on Foster Avenue with the elimination of the existing curb cut. So that'll give back 2 additional parking spaces to the community. So that's parking. The second issue we had was an interior side yard setback. We did not, in our analysis, nor did the zoning department in their analysis, pick up on the fact that there's a BG&E easement that's actually Belnor Street is actually in an easement, which is a lot. And therefore, our property was adjacent to a lot, which created an interior side yard setback. So our plans have basically not changed from the original plans that we worked with the community on for the previous zoning appeal. But it does create, because there is that easement, technical easement, it does create a variance request from us. So we're requesting 5 feet 6 inches from a 10-foot interior side yard setback, and that'll be on the east side of the property, on the Belnor side of the property.
Say that, so the exact, what's the distance for the
5
variance you
feet
need?
6
5
inch
feet 6 inches?
is the technical reduction. Is that the reduction? No, the reduction is actually 4 feet 6 inches is the reduction. We have 5 feet 6 inches from the property, so we need a
Okay.
reduction of 4 feet 6 inches.
Is the reduction, okay.
We also, we wanted to note that we have provided the community the plan that we're speaking of. They received it last night. We'll get that plan to you as well, that revised plan that shows this for the record for the board, what we gave the community last night. And we also agreed that we are going to work, there's a utility issue in the back. We're going to work it out to make sure that those utilities are on our property, and that we'll get the proper easements for title requirements so that they can maintain their utilities across the rear of this property. That's all I have to say.
Okay, Katie, you have all of that for the record?
I do.
Okay.
I just wrote everything down. So really the only 2 asks before the board are the side yard setback and the parking variance. The other stuff is information for us that you've reached out to the community, the concessions that you're making, the different things that you're doing.
Yeah, and for parking, it's the same as the last variance, 6, we had 22 parking spaces. We're just getting a clarification on what that reduction is, that's all. So we're providing the same amount of parking that we did in the last variance, 22 spaces.
Okay.
Yeah.
All right. Very well. Thank you for that additional information.
Okay, we have a couple of hand raised. So Mr. Foster, if you could stay quickly. I see Mr. England. I got him too late. He was here for Tanny. And then I know Miss Quezada is here for a case that's later, but it looks like we have someone here for Foster, a Daniel Crikey or Daniel Crite. So I'll unmute him now. Mr. Crite?
Yeah, Creedy.
Creedy, sorry.
That's okay. I've lived with it all my life. Yeah, we did have a meeting with Mike last night, and I have to say I'm speaking as an individual now, not as a member of the board of directors for the HOA, but just as a resident. I was happy with the plans that he presented last night. There was just one thing that didn't get clarified during the meeting, and that would be the financial cost of straightening out the problem with the easements. And it was my impression when this project first came up that Mr. Burton would be willing to cover the costs of getting that straightened out. Last night, it sounded like the HOA was going to need to be involved in that. And so I guess if he could offer some clarification, because I find it hard to support the project, knowing that we might end up as residents having a financial obligation in this matter.
I can clarify that. So for the board's understanding, there was a subdivision that Daniel is speaking about. It's 31 townhouses in that subdivision. It was done between 2001 and 2003, and it was permitted. Unfortunately, the previous developer did not record and work out an agreement and record crossing over the rear of this property to an alley to put in their sewer and cable. And so the sewer lines for the entire 31 townhouses and their cable for all 31 townhouses are buried underground in my backyard with no title. And so so I'm willing to work to get that squared away. But I know that at the end of the day, I'm going to have a legal document that they're going to have to sign. If they don't want to hire an attorney to review that legal document, that's up to them. But I'm going to get it squared away. Most likely, it'll be providing the city an easement through my property so they can maintain that sewer line, as there's a manhole and a sewer line, to be able to maintain that. And then as well as go to the cable company, give them an easement so they can maintain their cable line. Because anything the neighborhood needs to do to sign off to make sure that they're covered, I advise them, because I have legal counsel, they should probably have legal counsel on their side to confirm the documents that I'm getting signed are okay. Right? The bottom line is I'm willing, as the landowner of the adjacent property, to allow them to continue to maintain those untitled encumbrances on this property. I don't have an issue with keeping them there. They're in the rear yard setback. I can leave them there, but it's a very weird technical issue that honestly, it's above my pay grade and my expertise to figure out. I've been working on it for 6 months and I'm trying to work with them and make sure that we get it done right this time, right? Because it's the sewer for that entire community. And right now, just to give you a perspective, when I went to do my geotech work on the site, they wouldn't drill because Miss Utility had come out and marked everything, but did not mark the back. And they saw a manhole in the middle of the property and are like, we're not drilling. What is this? And that struck the whole thing of trying to figure out what all this stuff was. And through analysis, we figured out what it is. And so now we got to get it corrected so that it's properly recorded.
Okay, appreciate that additional information for the benefit caller. Ms. Byrne, correct me if I'm wrong, those issues don't impact board.
They don't.
Any variances that we have.
So it's definitely a private land matter between Mr. Foster and those property owners whose utilities actually run through his particular property.
And I know they want to hear this, so I'll state for the record that we're going to make it so that they can keep those utilities on this property and not have to move them. They're just going to have to work with us to figure out how to do that. That's all.
Okay. Thank you.
Thank you, sir.
Thank you.
Any other calls you
Go
need
back
to pick up?
and restate the variances just for the record, because there's been a
For
lot
the
of.
record,
Okay.
we're providing 22 parking spaces which means we need a reduction of 4 parking spaces.
Okay,
Because we have several units that are smaller than 500 square feet. That gives us a 2-car reduction already without a variance. So we need a reduction of 4 spaces for a total of 22 parking spaces. And we need a side yard setback on the Belnor side, on the east side, interior side yard setback of 4 feet 6 inches.
okay, great. Thank you.
Yep.
Okay, I have that as well. So I think, I think,
I appreciate everyone going through this, by the way.
No, it's helpful. We want to make the record clear and be sure that certainly we'll have to go through this again. So appreciate that additional information, Foster, and the board having heard the appeal with that additional information. We believe we have sufficient information to approve the appeal. Thank you so much.
Okay, thank you.
and, all right, so before we move on, there was an individual, Mr. Englander, who had his hand raised for Tanny, and I missed that. So Mr. Foster, I'm gonna give you the boot here from the panelists, or Mr. Burton, not Mr. Foster. All right, see ya. So and I just texted, tried to get a hold of Mr. Barry to see if we can get him back, but in the meantime, Mr. Englander, I've just unmuted you, sir. You had your hand raised for Tanny, which was the one we just heard, and, I'm sorry, but I didn't see that. Can you hear us, Mr. Englander? Okay, he's unmuted, but we can't appear to hear him, and he hasn't responded to me in the chat. So, all right, I've got a check mark, yes. But we cannot hear you. So Mr. Englander, if you could just please put in the chat, what your concerns are, and I'll see if I can get Mr. Barry back. I don't know why we can't hear him. Let me see if I can make him a panelist. Yep, I can make him a panelist. All right, Mr. Englander, try again.
Can you hear me now?
Yes.
We can.
Okay, there you go. Hi, everybody. Thank you so much for going back to me. I'm the next door neighbor, 2409 Taney Road. Generally, I do not have any problems with this. The variance, it was a call for. I just want to make sure that it's within. Since I haven't seen, I have spoken with them, and yeah, sounds generally fine, but I haven't seen any physical plans. So I just wanted to make sure that it was within the width of the current home that is on the property. That's what I was told, and if that's what the case is, then I'm fine with it.
Okay.
Sorry. Oh, hello. Oh, you also can see me now.
Yep, sure can. Good afternoon, sir.
All right, I just spoke to Mr. Barry. He's going to come back in, and hopefully he can answer that question for you.
Oh, great. Thank you.
So we'll just give it 1 minute. Let's see if he pops up. So it'll probably come in as Michael Kyle.
If we can't get him back, I do have the plans in front of me and I can talk about them, but it'd probably be better coming from Al.
I mean, I can take your word for it. I mean, as long as it stays, I'm generally comfortable with it as long as it's within the width of the house that's currently there. That's what I was told that the plans are.
All right, let me see if he's a caller. Hold on 1 second. All right, I'm going to go through the call-in user. So Al, if this is you, please speak up. Al, is this you? All right, we're going to go to, oh, wait, here we go. Looks like I have an addition. All right, let's try this one. Nope. Let's try this one. Nope. Let's see. Oops, I need to mute that person. All right. Just give them a couple minutes.
You want to move on and come back?
No, because this is the end of the consent docket, so we want to try to see if we can get this resolved. There he is. All right. All right, so Michael and Al made you both panelists and you are unmuted. And Mr. Englander, could you repeat your question?
Yeah, hi, Jeremy Englander. I am 2409 Taney Road. I'm the house right next door. I did discuss with Zoller, is the last name, about the plans going, but I haven't seen any physical plans. I'm generally okay with this. I was told that the addition is going to be within the width of the house that is currently on the property. If that's the case, then I have no objections or anything.
Put up the site plan. We can share the site plan.
Yes, please.
All right, I'll pass you guys the ball.
I'm not sure the easiest way to do that.
Actually, I just passed it to Becky. But let me see. Do you have it up on your screen?
I can. I wonder if I can also drop it. Can I drop the PDF in the chat?
Maybe. Let me, that's a good thing. Yeah, that would be, ooh. Oh, Becky pulled it up. Thank you, Becky.
Yeah, it's right here.
Okay.
So I zoomed in quite a bit so you can see this is the plan that we have, and we can share this with you. It's up on our website actually. And this is the addition right here, but you all can explain it.
And that's
if you want to.
this is the original home that's on the property right now, correct?
Mm-hmm. This is the original home here.
So,
And then,
so the addition is within within the limits of the width of the original property.
yeah.
Okay, then I have no objections.
Okay, thank you.
Thank you.
And Katie, appreciate the call to let us know. And Jeremy, thank you.
Thank you. All right.
Okay.
Have a good day, everybody.
You too.
All right, thanks. That'll resolve again, 2021-352, 2411 Taney Road. So thank you, sir.
Thank you.
Hey, can you guys hear me?
Yes, Bill.
Okay.
Although you're frozen on my screen right now. Maybe it's just mine. No, that's fixed. Okay, so we're ready to go to the regular docket now?
We are. We
All right.
are. We are definitely going for the regular docket.
Okay.
Boy, it's quite the technical day we're having, isn't it?
It's that. Maybe better to have it all on one day. Good days otherwise. Calling case number 2021-333, 428 South Ventilo Street. Kathy Williams is the appellant, and this is a request to expand the existing tavern located on the first floor into the second floor. I'll hear any reports from planning and staff.
Thank you. Planning Department reviewed this application, noted that this property is in the R8 zoning district, and the tavern is a non-conforming use in the R8 zoning district. This property was in the R8 zoning district and remained in the R8 zoning district from 1971 to the present time. And the tavern therefore has remained in non-conforming status since 1971. The zoning code does prohibit the expansion of a non-conforming use, and therefore the department recommends disapproval of this application because the zoning code does not authorize the board to approve an expansion of a non-conforming use.
Thank you, Mr. French.
Piggybacking onto what Mr. French said, again, this is a non-conforming use, has been a non-conforming use. It's a tavern in a residential zone. The board doesn't have the authority to expand the non-conforming use, and the zoning code expressly prohibits the expansion of non-conforming uses unless certain exceptions apply, and that would be, for example, life safety, right? So if a code changed and they had to add ADA, right, which might expand their footprint, or they had to change their stairwell, that might have to expand their footprint. Those are the kinds of limited exceptions in which the board has the authority to grant the expansion of a non-conforming use. But to grant the expansion of a non-conforming use to essentially create more space for that non-conforming use, the code does not permit, and the board cannot or doesn't have the legal authority to do so. So I've got Miss Williams here. I've made her a panelist, and Miss Williams, I've unmuted you.
Hello.
Good afternoon, Ms. Williams.
Well, my thing is the space has always been there. It used to be apartment, but then when I got it, it was just open space upstairs. So I just wanted to be able to use it. I mean, the bar is downstairs. It's nothing, no bar, anything is going upstairs. It's just an open space, and I just wanted to be able to utilize it. So that's the only thing I wanted to do.
Well, unfortunately, you're unable to utilize it for expansion of the tavern, which is what your application requests, apparently. So there may be other uses, but one of those uses would not be any expansion of tavern. And that's all that we have before us today.
Oh, okay. I'll go back and check. Thank you.
Okay, thank you, ma'am. All right, I'll conclude that matter. Move on to case number 2021-349, 466 Cornell Street. Marianne Cusada. This is a request to use the premises for 2 dwelling units and commercial use, barbershop, on the ground floor street level. And I'll hear from planning and staff.
Thank you. Planning Department has reviewed this application. According to records available to the Planning Department, this property is recorded as a single-family dwelling. This is in the R7 zoning district, and the zoning code requires an ordinance for approval of a conversion of a single-family dwelling to a multifamily dwelling in the R7 district. Separately, the application also proposes a street-level commercial use. The way this particular house is built, as an end of the row, the end wall is actually on Eastern Avenue and becomes a storefront along Eastern Avenue. The department has looked at the building itself and has noted that there obviously was at one time some type of non-residential use of the basement. There is a door and a set of store windows in the wall facing out onto Eastern Avenue. The department is therefore recommending that the portion of the application pertaining to the use of the premises as a multifamily dwelling containing 2 dwelling units be disapproved because the zoning code does not authorize the board to approve conversion of a single-family dwelling to a multifamily dwelling in the R7 zoning district where the property is located. The department would have no objection to approval of use of the basement level of the premises as a neighborhood commercial establishment, such as a barber shop. The applicant can provide the board information showing lawful prior use of the premises for non-residential use. Thank you.
What was that last part, Martin?
The department has no objection to approval of use of the basement level of the premises as a neighborhood commercial establishment, such as a barber shop, if the applicant can provide the board information showing that lawful prior use of the premises included a non-residential use.
Okay, thank you.
I think we can assist with that, actually. So as mimicking what Mr. French said, the records that staff were able to pull up through the land use card shows a varied history, including commercial uses, but the most recent is from 1992, where the lower level was used as a delicatessen in an office with 1 dwelling unit upstairs. So Mr. French is correct based on the land use card. We only ever have 1 dwelling unit here. So the board cannot approve 2, but the board can approve neighborhood commercial. And we do have a history of neighborhood commercial in the lower level at this spot. And I believe Miss Quezada is here. So I've unmuted you, ma'am. Miss Quezada, Marion?
Yes, hi, this is Marian. Yes, can you hear me?
Yes,
Yes,
and
we can,
Marion,
ma'am.
I just want to confirm, Miss Witt and I spoke with you last week, correct?
Yes, yes, ma'am.
Okay.
All right. Ms. Quezada, did you hear the statements from planning regarding
Yes.
the history of the property?
Yes.
So that do you understand that the board is without authority to grant approval for the use of 2 dwelling units because this property is only lawfully designated as a single family. I'm sorry, is that right? Yeah.
Right, one dwelling unit.
1 dwelling unit.
Right.
However, there is because we do have evidence of the history of the commercial use, the portion of your application seeking to operate a barber shop on the, it says ground floor street level, I believe would be appropriate. Is there anything you want to add to that?
Oh, I appreciate that you granted that barber shop. Yes, I'm going to take it now as a thank you very much. And I try to see if I can go through the city council, see if I can get my dwelling, the one store, I mean, the one dwelling unit to a multifamily, because I have another property next door, 464, which is a multifamily unit and the same size, exactly same square footage.
Yeah,
And I
very
thank you very much for you granted the barbershop, and we will start working on it. Thank you very much.
Thank you, ma'am. Katie, just a quick question.
Sure.
I think Mr. French was referencing a basement level, and the applicant is referencing, I guess, ground floor street level. Does it matter whether it's basement or first floor?
Mr. French, can you shine some light on that?
This building is an end of the row.
Mhm.
The topography slopes upward from the intersection of Hornell and Eastern. So the house is partially dug into the land, so to speak.
Mhm.
The end wall of the house fronts on Eastern Avenue, and at Eastern Avenue, it is a full exposed basement wall, which becomes a storefront, which is what it was. However, the front of the property, if you're looking from Hornell, has a set of stairs going up and, earth banked up against the front of the basement wall. So it appears to be a two-story dwelling from Hornell. And that's basically why the term ground floor was used. It could also be interpreted as basement. If you're using Hornell as the address, then technically it's the basement level of the property.
Gotcha. Understood. Thank
So
you for the
we'll use ground floor then.
Yes, I wanted to make sure what's the, because in some cases it's basement, the other cases it's ground street level, because it's a street level. So I just want to make sure what's the right term that I have to use for my applications.
So yeah, so I guess, so can we say ground floor then, rather than first floor? Is that the better term, Mr. French, do you think?
That's what it is.
Right.
Well, here's the problem. If the property is addressed as 466 Hornell, then technically it's the basement of 466 Hornell. It's the ground floor facing Eastern Avenue. But
Okay.
the property's not addressed on Eastern Avenue.
Oh, I see.
Right.
Got it.
All right, so it's got to be then basement of Cornell. Okay.
Okay.
All right, I think that was helpful for all of us.
Yes.
Thank you. Oh, yes, thank you very much. Thank you.
Thank you.
All right, thank you, ma'am, for your presentation.
Thank you.
Let's see. All right, moving on, case number 2021-354, 1127 North Carolina Street. William Brodus is the appellant, and this is a request to use the premises for 4 dwelling units, variance required for off-street parking. And I'll hear any reports from planning and staff.
Thank you. Planning Department has reviewed this application, notes this property is located in the R8 zoning district, also in the Gay Street 1 urban renewal plan area. That urban renewal plan does not prevent the proposed use of the property. The records available to planning staff indicate the property was last authorized for use as a single-family detached dwelling. However, that's derived possibly from a provision of the previous zoning code, which was in effect until 2017, which mandated that all vacant buildings after 12 months or more of continuous vacancy be assigned the status of a single-family dwelling. The building on this property was vacant during the first decade of this century. Therefore, that may be the reason it shows up as a single-family dwelling. There are some records that the Planning Department staff have been able to review, which suggest the property may have been used as a rooming house, not necessarily as a multifamily dwelling, prior to its abandonment. Therefore, basically, the department is concerned that the applicant be able to provide some type of verification that this property was used for a purpose other than a single-family dwelling in the past lawfully, in order for the board to be able to consider this. The department therefore has no objection to the application if the applicant establishes that this property has a record of lawful use as a multifamily dwelling or some other use that was not a single-family dwelling use.
Thank you, sir.
The issue with this is that he's requesting 4 dwelling units. So that would require a variance for 4 off-street parking spaces. There's evidence in the records from Department of Housing and Community Development that the property has been vacant for many years, possibly up to 20. We could not find any land use card on file, so there's no evidence of past legal conversion in the permit systems or documents available to us. So we would need to see something from the applicant that it was a legal multifamily at some point. So there's nothing in city records that we could find that show that it's anything other than, or has been used as anything other than a single family dwelling. We do not have, again, the land use card or the permits for this. So I've elevated Mr. Burtis to a panelist and he is unmuted.
I also just wanted to pop in and say Roxana just sent us an email, Katie, that said that there's a posting issue or a possible posting issue. We don't have proof of posting for this address.
Oh, Mr. Burtis?
Is he online?
He is. I've elevated him to a panelist and he should be unmuted. Mr. Burtis? Let's see if he's in here anywhere else.
Hello?
Mr. Burtis?
Hello.
Hello?
Hello? It's not the camera.
Is that Mr. Brodus we're hearing, you think?
I think so. Mr.
Can you hear
Burtis,
me?
can you hear us?
I can hear you.
How about me, Mr. Brodus? Can you hear me?
I can hear you too.
Okay, so this matters before us at for 1127 North Caroline Street. And you're seeking to use it for 4 dwelling units. Were you able to hear Mr. French from Planning Department discuss
Yes.
the history of this property?
Yes, I was. I will be able to provide him proof that it was before our multifamily with BG&E meters. And also, we do have the required off-street parking in the rear of the property. So if I
Okay,
can,
well,
I would like to postpone this and
Okay,
come back with the things that y'all need. And I'll
gotcha.
address the posting issue too.
Okay, very well. Looks like we can take care of all those things then. So we'll go ahead and enter a postponement on the docket here, and
All
we
right,
can.
Mr. Burtis, can you get those things together by April 5th?
Yes, I can.
All right, we're gonna move you to April 5th. So you need to make sure you get your sign up and that it has the April 5th date. And then submit the documents that you wish us to provide to the board. Really probably no later than the 29th of March.
All right. Thank you.
Thank you, sir.
All right. Have a good weekend.
That matter is postponed. Great. All right, moving on. Case number 2021-355, 814 Park Avenue. Adam Carvalho is the appellant. This matter addresses variances to bulk and yard regulations related to the demolition of an existing one-story parking structure located in the rear and to construct a 3-story apartment building in the rear that will contain 8 additional dwelling units. And the variance is required for off-street parking. I'll hear from planning and staff.
Planning Department has no comment on this application. However, the department does note for the record that this proposed redevelopment of the rear of property facing onto Tyson Street has obtained approval for the proposed second multifamily dwelling structure from the Commission for Historical and Architectural Preservation, this property being located in the Mount Vernon Historic District. Thank you.
So this is conditional use, I'm sorry, the variance is required related to the demolition of the existing one-story parking lot structure in the rear, the construction of a three-story apartment building in the rear that will contain 8 additional dwelling units. Variance is required for off-street parking and a rear yard setback. So the rear yard setback, 10 feet is required, 0 is proposed, so it's the full 10-foot setback. Off-street parking spaces, 8 are required, 2 are proposed, so it's a 6-foot variance request. The reason this is on the regular docket is this morning at 9:48, we received a letter in opposition from John Swift, who said he could not be here. So given the fact that we were not able to provide this letter to the board or to the opposition ahead of time, I'm just going to read it into the record. And then, or if you want Mr. Carbello to go first, and then I can read it into the record, Mr. Chair, however you want me to move forward on that.
Why don't you just go ahead and read what you have, and then
Okay.
maybe Mr. Carbello can address that one.
Okay, this is from John Smith. He's at 838 Tyson Street. I'll be unable to attend today's online hearing, so I'm submitting my comments in advance. I must object in the strongest possible terms to the proposal by the owner of 814 Park Avenue to tear down an existing garage, construct a 3-story, 8-unit apartment building, and receive a variance from the statutory parking space requirements. First, the owner has shown little ability to properly maintain their existing property. 814 Park Avenue has a history of code violations, both interior and exterior. For example, see code violation 2017294A and 176255-4A. The structure proposed for demolition has been left unsecure from the elements in what can only be described as an attempt to demolition by neglect. Sumac trees are currently growing out of the structure, causing cracks in the exterior walls, which are also settling because of a lack of repointing. The first 6 courses of brick starting from the ground show significant mortar loss. The photos below are from November 2020, March 2022. Is there any evidence that the 2019 violations were mitigated? The trees predate the code violation. So I'll just do that. Is one of the photographs. There's another photograph. And then the third photograph. So I think this shows the rear probably best.
Katie, will you put your hand behind the paper when you hold it up so that I
Yeah,
can't see
so
both?
that the light doesn't go through. Is that better?
Yeah, a little bit.
All right, so that's one. And then these are the 2 on the back. So this is, I think the aerial shot.
Looks
And
like it.
then the first courses of brick. Okay. And then here's another photograph. Yep. So this is the roof structure of 814, and then the first courses of brick, and then this is the side. All right, and then I'll finish the end of the letter. Second, the lot has a structure with 11 rental units and inadequate parking. The back end of almost every other property that faces the even numbered side of the 800 block of Park Avenue, with a lot that extends to Tyson Street, uses the rear of the lot for parking, whether gravel surface, paved parking lot, or garage. The inclusion of 8 additional rental units and no additional parking at 814 forces cars onto West Madison and Park Ave, and even further away possibly. Those 2 streets already suffer from scarcity of parking for current residents. If we assume 1 car per new unit, which is a conservative estimate, that is enough to take up the entire side of West Madison between Park and Tyson. The current rental structure on 814 Park Avenue lot would require a parking space variance if it were built today. Parking on public streets is good held in common. Are we going to let the owner of 814 Park Avenue more than their fair share of the public good by having 19 rental units on one lot with a single variance requiring them to provide only 2 parking spaces? Those 2 parking spaces already belong to the existing structure, which means the request here is really to build 8 units and include no parking whatsoever. A decision to allow variance simply enriches one absentee property owner at the expense of the property owners who live in the neighborhood. 814 Park does not deserve special treatment. Third, the proposed structure, despite the opinion of CHAP staff, is completely out of character for the 800 block of Tyson. There's no other structure that fronts onto Tyson Street with this kind of potential occupant density at the rear of 814 Park Avenue has. Every other structure fronting Tyson in the 800 block is 2 to 3 stories at most, with 2 rental units. The majority of the residential structures on the 800 block fall under R8 zoning, while only 2 current residential structures fall in to R2 zoning. The proposed structure at the rear of 814 Park Avenue would be the third. Surely the zoning prevalent on the vast majority of the 800 block deserves some consideration in the calculations for the appropriateness of the proposed structure at the rear of 814 Park. I'm also not clear how 19 units on the lot meets the density limits for R2. The proposal for the rear 814 Park Avenue takes advantage of overly permissive zoning and demands a use that would never be allowed if 814 Park were divided into a lot facing Park Avenue and a separate lot facing Tyson Street. In addition, the substantive reasons above, I have questions about the application for the review itself. Unless I'm somehow misreading the application, the applicant lists the dimensions of the present building as the same as the lot. This is false. The application lists the size of the proposed building as the same size as the lot. The present building and the proposed building can't both occupy the same space at the same time. The application for this variance should be rejected on technical reasons alone. If the proposed building is 30 feet by 176 feet, the area is not 4,845 square feet. The architect warrants under threat of perjury that the application is true and correct. How can any of the calculations be considered accurate given the basic errors in the form? The application for review is clearly not true and correct and should be dismissed. It's remarkable to me that a step as significant as demolishing a current parking structure wouldn't come with the requirement to first mitigate the parking situation for the existing rental structure with 11 units. Let the absentee owner either repair the existing parking garage to code or demolish their garage and provide adequate parking for their existing tenants. Either course of action harms Tyson Street. To conclude, approving this request is rewarding absentee landlord who has shown little interest in the neighborhood except to profit from it. It would also represent theft from the public to enrich private landowner rather than requiring the landowner to take personal responsibility for their property. So that's the letter.
Okay, not there. Okay. We have Mr. Carballo on the line.
He's unmuted and a panelist.
Okay.
All right.
Good afternoon, Mr. Carballo.
Good afternoon. Thank you for allowing me to speak and present this project. If I can, I guess I'll present the project and then I'll respond to the letter as best I can. There's a number of factual inaccuracies in that letter that I can respond to. This property is located at 814 Park Avenue. This is located in OR2 zoning district, not an R2 zoning district, an OR2 office residential 2 zoning district. This is a zoning district that does allow for office and residential use. The majority of the properties on this block and in this zoning district are apartment buildings. Many of them historic in nature, on fairly generous lots. The lot that we have, as we sort of accurately presented in our variance documentation, shows the lot at 30 feet wide by 176 feet deep, or 5,280 square feet. OR2 allows for 1 dwelling unit per 200 square feet of lot. By that calculation, this lot allows, as a matter of right, up to 26 dwelling units. We are proposing 19, which is not nearly as many as we could allow. There are 11 units in the existing building, and we plan on redeveloping the rear accessory structure as 8 units. As Mr. French mentioned, we went through an extensive review with CHAP and the planning department. We had numerous public meetings, and the project actually used to be larger. We initially had presented a 5-story structure, or a 4-story with a penthouse, that would closely match the scale of those structures along Park Avenue. However, given the sensitivity of the size of property along Tyson Street, we reduced it down to a 3-story structure. there are, and if I, do I have the ability to share, share any data?
I just passed you the ball.
Excellent. Okay. For orientation purposes, this is our structure back here. This is 814 Park Avenue. This is at the corner of Madison and Park, or just beyond the corner of that. There are a number of very, very tall structures, including obviously the former Presbyterian Church. You can see our structure here, 11 units, and then this larger accessory structure. And let's see, we'll also present our presentation. This is our zoning document. We did, and I will admit, we did have the incorrect zoning district listed on our variance drawing site plan. However, the dimensions of the lot are accurate. And what our proposal is, the existing accessory structure is basically a large open garage space. It did have a single door and a overhead garage door. However, it only provided parking for 3 vehicles as per DOT standards. What we're presenting is a 2 parking space as well as a private dumpster that the property does not have currently. We're moving to private trash removal, whereas previously it was relying on public trash removal. So we're providing this amenity, and we're also providing, 8, modest apartment units. We have, 2 bedrooms and 6, studio units, which is in keeping with the area. Here are some photos of the actual garage in question. It's a single story, one overhead door in the middle. As you can see, the scale of the properties around, there's a very generous building at the corner of Madison and Tyson. Here's a 3-story across from the property as well, across Tyson Street. And as you can see here, we've sort of designed this new structure to keep in scale with the properties around it. As far as the local area, this is a very walkable portion of Mount Vernon. There are, easy links to public transportation. There's also easy links to areas of commerce, areas of office, and sort of workplace areas. It is not uncommon to have density in this part of Mount Vernon, and this would not be out of character for the vast majority of apartment buildings that are up and down Park Avenue. And I will remind that as a matter of right, we could have gone up to 26 units, but the owner did have, in working with CHAP and also addressing the concerns of the neighbors on Tyson Street, we reduced the size of this building, and we also reduced the size of the number of dwelling units down to 8 units plus 11, or 19 total, which is 3/4 of what we could actually provide. The variance for parking would not be out of character for this part of town, or for the vast majority of the buildings up and down Park Avenue. It's just simply the lots aren't large enough to support any additional parking, and the majority of the buildings don't have more than 2 or 3 spaces at most, let alone 1 space for every dwelling unit in this part of town.
Mr. Carvalho, thank you for that additional information. Does that pretty much address the opposition arguments?
Yeah, there was, I guess, some. He alluded to the fact that he's making accusations of the building owner that they're not maintaining their property, and I think, and also referenced, demolition by neglect. I think that's complete nonsense and unfounded. It's also not part of the purview of the zoning office. I will say that the owner is an older gentleman. He's also in the process of handing over management of this company, or excuse me, management of the property to another party who is better equipped to maintain the property. So I think those issues that the neighbor on Tyson Street identified, I don't think are long-lasting issues as he transitions, and effectively he's retiring. So he's passing along this to someone else to maintain.
So again, so the only variances or sought before us, conditional use variance, rear yard setback, 10 feet required, 0 feet proposed, off-street parking, 8 spaces required.
Yeah, and I will, and also reiterate that the existing property already enjoys a 0 foot rear yard setback off of Tyson's. And effectively this is a 3-story carriage house is what it is. And it's very common, that those carriage houses that do exist in Mount Vernon, they enjoy a 0 foot rear yard setback to the alley or the alley street. In this case, it's actually Tyson Street. It's a true street. It would be unusual if we were asked to create a 10-foot setback from that street. We're basically maintaining that existing setback, for this sort of carriage house structure.
How long has the present owner owned the property?
Let me take a look on it appears he purchased it in 2016 or 2000. There was a sale in 2005 and one in 2016. So I believe it's probably 2016.
I have a quick question, if I may. You may have already answered this, but was there already a parking variance given to the existing structure of 814 Park?
I don't know. I don't know the answer to that. I mean, it is a historic building. It's a very old building. So,
I think Mr. French, can you chime in there?
Well, it's not going to be a helpful chime in. If the property was converted before 1971 to a multifamily dwelling, then before 1971, no off-street parking was required. So if it was already multifamily by the time 1971 rolled around, then basically they were given a credit for the spaces they should have provided but did not.
Yeah, unfortunately, the SDAT does not list an estimated year of construction, but suffice to say, building was most likely built in the 1800s, and I don't believe it was a single family house given just the size of it. It's possible, but I believe it's been an apartment building for quite some time. So to answer your question directly, I don't believe there's a variance for the existing 11 units because they were allowed as a matter of right without the requirement for parking.
Thank you.
Anything else for Mr. Carballo?
I'm good.
All right. Katie, we don't have any callers on this one.
No, I don't believe we do. I don't see any. I'm checking. No hand raised. I've got one call-in user just for out of abundance of caution. I'm gonna unmute that person.
Okay.
Nope. That's I think that's it. I think everybody else is here for the last one.
All right. Mr. Carballo, if there's nothing else, then we'll take this matter up, at the appropriate time. Thank you, sir.
All right, thank you so much.
Okay, we'll go to, we still have. Okay, so 400, last case in the docket. Calling case number 2019-400, 5002 through 5004 York Road. The appellant is AP Northeast Property LLC. In this matter addresses the BMZA enforcement of conditions contained in the January 6, 2020 resolution. Hear from, I don't know if Martin has anything to add on this, but planning and staff, if necessary, regarding the background of this matter.
For the record, the planning department has no comment on this appeal.
Thank you, sir.
Okay, so this is a matter that's before the board based on the authority in the zoning code. It says, after notice opportunity to be heard, the Board of Municipal and Zoning Appeals may, well, here, let me back up a little bit. So the board has the authority under 5-409 to revoke, suspend, or modify conditional uses that they have issued if it's determined that the occupant or the owner or the operator failed to comply with the terms of those conditions. And the code sets forth specific criteria, and it starts with the zoning administrator. So the zoning administrator has to issue a notice of violation, bringing to the owner or operator's attention that they are failing to comply with the board's conditions. If they fail to respond to the notice of violation, the zoning administrator then sends a letter saying, hey, you have 30 days to comply with this notice and order. If you fail to comply with this notice and order, I'm going to refer this matter to the BMZA for hearing and review to make a determination as to whether or not, one, you have complied with the order, and if not, whether your conditional use should be revoked, suspended, or modified. So what we have before the board is a conditional use for a drive-through at a Popeyes restaurant at 5002-5004 York Road on January 6, 2020. And they were subject to the conditions put forth in a memorandum of understanding that was signed by the Radnor Winston Improvement Association and the applicant's representative. That MOU was made part of the board's order. And once it's made part of the board's order, it then becomes enforceable under the board's order. The conditions included mutually agreed upon landscape plan, adding trash cans, signage, and litter control. The association complained about these conditions that were not met. Department of Housing and Community Development, the Zoning Enforcement Office, which is handled by Special Investigations for Department of Housing and Community Development, went out, issued those notices. The zoning administrator approved those notices. They're multiple times to cure, and there's been no response. So again, the board has the authority under 32-5-409 to revoke, suspend, or modify the condition of the drive-through use. Specifically, after notice and opportunity for parties to be heard, if the board finds that the condition, restriction, or limitation imposed under the subtitle has been violated, the board may take any one or a combination of the following actions. 1, revoke the use. 2, suspend the conditional use to completion of corrective action or other conditions set by the board, or affirm the conditional use subject to the schedule of the correction action with the provision for automatic termination if the schedule is not met. So I believe we have, and in light of the fact that this was referred to us by the zoning administrator, we'll call on the Department of Housing and Community Development first for their enforcement of the zoning code.
Hey, Katie.
Yeah.
What's the closest cross street? What's the closest cross street to this address?
This is it?
It's at Winston Avenue.
Thanks, Becky.
It's a little bit north of Cold Spring. It's the Popeyes on the left if you
Yeah, I
come
know.
from
Yeah,
Cold Spring.
that's what I
Yeah.
thought. Yeah, I
All
got you.
right. And actually, before we start, if a representative for the Popeyes is here, if you could either put it in the chat or raise your hand so that I know who you are and that you're here. All right, so, let's see, do we have someone? All right, not yet. All right, so, I guess, James, do you want to go ahead and start with DHCD? And then there are community members here that would also like to testify.
Yes, I think that's where we need to begin. So if we
Okay.
could hear from that representative, that'd be great.
Okay, so Mr. Fox, I'm making you a panelist, and Mr. McGinnis, I'm also making you a panelist. So Mr. Fox is the attorney for Department of Housing and Community Development, and Mr. McGinnis is the special investigator he's chief of special investigations for zoning.
Thank you.
Thank you, Mr. Bernie. Good afternoon, everybody.
Good afternoon, sir.
Hello.
Investigator McGinnis, are you on? I don't see you, so I just want to make sure before I start asking you questions here.
We can see him.
Okay, there we go. I can hear you. Ms. Byrne, did you want me to share the exhibits, or did you want to pull those up and go through them?
Well, normally I would say that I would do it, but given my technical difficulties today,
Sure.
Mr. Fox, I actually don't think I have access to the folder and the exhibits that you provided. So if you would not mind doing that, that would be awesome, and I will pass you the ball.
Okay, can everyone see that? It should just say Exhibit 1.
Yes, sir.
Okay. So, Mr. McGinnis, could you just state your full name and occupation for the record, please?
David McGinnis. I'm the director of the Special Investigation Unit for the Baltimore City Department of Housing and Community Development.
Okay, and how long have you had that role?
I have been the director.
I
think
can't
we may
hear.
have lost you on that one.
Looks like we've lost him a little bit. Just in the interest of time, if Mr. Fox, if you would like to proffer, and then we could always have Mr. McGinnis verify. I'm hoping that
Sure.
we get him back.
Sure, absolutely. So if we can go by way of proffer, Mr. McGinnis is now the chief of the Special Investigations Unit. Prior to that promotion, he was an investigator assigned to investigating the case with regard to 5002 York Road. Would you like me to proffer through the exhibits as well, or?
That's fine.
Okay. So if you can see Exhibit 1 here, this is the BMZA resolution dated January 6, 2020. If you scroll down to the end of it, the outcome of the resolution was that the petitioner's request to add a drive-through facility to an existing restaurant was granted on the condition that a memorandum of understanding was submitted to and incorporated into the resolution. The MOU is later on in the resolution and can be found here. That has a few different items that the owner and operator was supposed to follow. Specifically, the litter control. Popeyes was to remove all trash cans generated by the business on the property, including landscaped areas in an adjacent western lot. They were supposed to install 2 additional trash cans next to the customer parking and 1 additional trash can in the drive-through area. With regard to prohibition of idling vehicles, Popeyes was also supposed to prohibit idling vehicles and post signs telling both delivery trucks and customer vehicles that that prohibition was in place. There's also agreement with regard to landscaping, that Popeyes will install a landscape plan consisting of native plants as reviewed by and accepted by the community association. There is also rules here that with regard to maintaining the exterior, specifically removing dead plants and replacing them with the plants approved by the landscape plan. So all of this was agreed to by Popeyes and the owner, put into an agreement with memorandum of understanding with the community, and made part of the board's resolution back in 2020. Here, again, just attached to, I think I might have to zoom out a little bit, but these are the landscape plans submitted by the community that show the landscaping that was supposed to be done at the property. Just drawing your attention specifically, I have to zoom in again here, but the different types of plants that were supposed to be submitted, it's 161 different plants, trees, shrubs, that were supposed to be planted at the property that the community had agreed to with the Popeyes. So this matter was then referred to, as Ms. Byrne had indicated, to the Department of Housing and Community Development to look into whether or not the owner operator was complying with the BMZA resolution. Mr. McGinnis had gone out to the property on April 28th, 2020, and documented through our housing inspection log the pictures that he's seen. And I can scroll through these here. First, we have a overview of the Popeyes area, and then Mr. McGinnis took pictures of both the north side and the south side of the property and the flower beds that were supposed to have the landscape plan. As you can see, there are no trash cans, no signs with regard to littering, no trash cans with regard to idle parking. The landscape plan had not been implemented, and there's a series of dead plants around the planting bed that have been removed or maintained. So after the...
What year was that?
This was, I can zoom in here, the date, but it was April 28th, 2021.
Thank you.
First inspection. So after the inspection is completed, Inspector McGinnis had issued a housing violation notice, which is here as Exhibit 3. The housing violation notice was issued on May 12th, 2021, and cites the 4 different items that were missing here. Again, it was with regard to the trash cans, the signage, and the maintenance of the landscape manual and the maintenance of the flower beds. The violation notices here, there's a lot of them in the exhibits here. The reason that is because CHIP will issue, our housing inspection log will issue a new violation notice to each address that it was sent to. But Investigator McGinnis did send these out via first class and certified mail to each of the addresses on the violation notice, which was all the addresses that we had in the system for the owner and the operator to make sure that they were on notice of the housing violation. So I will scroll through all of these and get down to where Mr. McGinnis had posted the notice as well. So he actually went up on May 25th, 2021 and posted the notice on the Popeyes. I will also proffer that on that day, Mr. McGinnis actually had a discussion with the manager on duty who refused to sign for it, but Mr. McGinnis did explain what was going on and left his contact card to either have the owner, the operator, somebody from Popeyes corporate to contact him to discuss the violation. After the violation...
Can anybody hear me?
Yes, sir.
Yeah.
Can you see me?
We can.
Would you like
I
me
see
to
Katie.
continue to proffer, or would you like me to have Mr. McGinnis testify?
Whatever your choice is, whatever's more expedient.
I think it would be quicker if I just run through it. And Mr. McGinnis, if you want to add anything that I'm missing, feel free to jump in.
That's fine.
Absolutely, sir.
So after the violation it was issued and Mr. McGinnis had spoken with the manager on site, he went back and did another inspection to see if there was compliance with the resolution. That was on August 30th, 2021. And I'll go through, the pictures are almost the exact same, so I won't spend too much time going through them. But as you can see, the property is in the exact same condition. None of the items in the resolution had been met and the housing violation notice had not been abated. Exhibit 5 is Mr. McGinnis's third inspection of the property, which was on November 2nd, 2021. Again, I won't go through these too quickly, but again, the pictures look essentially the same. The property is still, there's no landscaping, there are no signage, no additional trash cans as required in the MOU. So once, after those 3 inspections and not hearing anything from either the owner of the property or Popeyes, the manager, or anyone reaching out to Mr. McGinnis, this matter was referred to the zoning administrator, who sent a letter on November 18th, 2021, informing the owner operator, as well as the neighboring properties and the community association and the applicant that this matter was being referred to for an enforcement action. They cite here the 4 items that were in violation and give them 30 days to correct those, or it will be sent to the BMZA for potential enforcement. This is all sent via first class and certified mail to all of the residents listed on the property, as well as all of the individuals copied here to give them notice of the potential enforcement action. Mr. McGinnis also posted these on the property. He posted again the violation notice from DHCD posted a copy of the BMZA resolution as well as the letter from the zoning administrator. So here's the overview of those postings as well as the close-up individuals for each of the items that were posted on that day, and this was on November 18th, 2021. Mr. McGinnis also made contact with the manager on duty regarding the possible revocation, explaining what was going on, and again, trying to open up that dialogue to have them either abate the violations or at least open up the dialogue to discuss those with the HCD. Mr. McGinnis hadn't heard anything again, so he went back and did an investigation on January 11th, 2022, and this was his last inspection of the property prior to its date. Again, as you can see, the property is in the exact same situation as it was during his first inspection. There are no additional trash cans, no signage with regard to loitering or littering or idling vehicles, and the landscaping still had not been corrected or properly maintained. Because of that, the BMZA then issued a letter to both the operator and the owner of the property and the applicant, letting them know that this matter is going to be scheduled for a public hearing today at 1 p.m. This letter was sent out via first class and certified mail as well to all the addresses listed. Mr. McGinnis also went out to the resident agent's address and hand delivered it. A gentleman by the name of Fernando signed for it on February 25th, 2022. Mr. McGinnis also went and posted this notice on the Popeyes. Again, you can see here the broad overview as well as a close-up of it. When he was at the resident agent's location, he again had his third conversation with representatives of Popeyes, letting them know what was going on and also putting them on notice of today's hearing. So that is the extent of the exhibits and the extent of what Mr. McGinnis would testify to if he were testifying as a witness. Mr. McGinnis, do you have anything to add from what you could hear?
No, sir. I mean, every time I spoke to a representative of the management, I made it explicitly clear that this could end up in the revocation of their conditional use. The manager for the final posting was the same manager I spoke to when I last posted the notice at the property. So we were already familiar with each other, and he, acknowledged that he had passed it on to his superiors and had not heard anything back.
Okay, thank you. And at this time, I'd just like to request that the exhibits 1 through 8 already submitted be admitted as part of the record. And as Ms. Burnett indicated, under Section 5409 of the Zoning Code, the board does have the ability to find if a condition of the resolution has been violated, to either revoke the conditional use, suspend the conditional use subject to corrective action, or affirm the conditional use with a schedule for corrective action with a provision for automatic termination if that schedule is not met. Here, the DHCD has provided ample evidence that that the appellant has violated the resolution issued by the BMZA. They've failed to take any corrective action or even respond to any of DHCD's notices, despite 4 inspections, 4 violation notices, and 4 conversations that Mr. McGinnis had with the representatives of the property, and have ignored all of those throughout the last year. Given their lack of either communication or attempts to remedy the situation, DHC is recommending that the conditional use be revoked. Thank you.
Mr. Fox.
I believe I may need to stop sharing. Bring it back. There we go.
All right. Thank you, sir. Katie,
Did the
what will you
neighborhood
now?
association make the referral?
Yes, we did receive complaints from the neighborhood associations, how it became in front of DHCD. And I believe they're here to
Thank you.
about the impact of this as well.
Okay.
I guess if no one has any questions for Mr. McGinnis, we can move to the neighborhood association. I believe they indicated that they have 3 different people from the community that wish to speak on this matter.
Okay, go ahead, we'll hear them.
Okay, we'll start with Dan Pontius. So Dan, I've made you a panelist, and you're unmuted. And then if you could tell me who to call, what order to call next after you're done.
Okay, great. Can you hear me? All right, here we go. All right, well, first of all, I want to thank, I'm Dan Pontes, I'm the president of the Radnor Winston Improvement Association, and I really want to thank Mr. Fox and Mr. McGinnis for being so incredibly thorough. I mean, we've been frustrated, but boy, that presentation really takes your breath away there. I mean, I didn't realize they posted 4 times. But anyway, I'll start off and then other people can fill in some details, although like the DHCD folks were super thorough. I guess I mostly want to say I was elected to this position in 2018. So in 2019, I was relatively new. We did a similar process with McDonald's, which is right up the street. But I was not involved. That was before I was president. But I just want to let you know that it is possible. The Popeyes folks can be responsive if they want to be, because they approached us through our then councilman, Bill Henry, in the summer of 2019, saying they wanted to add drive-through. And we, they brought us fried chicken and biscuits. We had many meetings. And we really thought did not really have a relationship with Popeyes at that point. I've lived here for 24 years. I mean, our neighborhood is very active in the York Road Partnership, working to improve the York Road corridor to make it a more thriving commercial corridor with, more attractive to people who drive or walk through. And so we thought this is a real opportunity, and Popeyes was engaging with us. We thought this would be a great chance to have a better relationship. We were having trouble with middle of the night deliveries to Popeyes. So we got to talk to them about that and put that in the MOU as well. And then, the beautification of the corridor, the landscaping, there are trees with ivy. Those things were in there too. This is really a chance. We have an organic community garden behind the Popeyes on Loyola property. The one thing they did was build a fence back there, which is great. But we came out, and you notice the scribbles on the MOU. That's us at the BMZA hearing on December 3rd, 2019, negotiating the last little things. I mean, we really worked this through with them. By the time we got up in front of the BMZA to testify in support of this drive-through, we felt like this would be a new day for us and Popeyes, a new relationship, a new positive impact on the York Road corridor. And now I know not to take it so personally, because you guys are getting the same exact treatment that we are getting. By August of 2020, I mean, obviously the world kind of fell apart that spring, and I'm sure Popeyes was very glad they had a drive-through in the spring of 2020. They got the drive-through up, they got that done quickly. But in August, there were just a few plants that were mostly dying because they weren't getting watered. And so we started reaching out. Drew Schmidt-Perkins, who's here, can talk about reaching out to the people at the business. Then I referred them to Ed Bach, who had come down from Philadelphia to talk with us when they still needed the drive-through. He didn't respond to her, so I got involved in February of 2021, emailed him several times, called him, left voicemail messages. He responded sort of half-heartedly a couple times and then stopped responding. And that's when we turned it over to DH. That's when we contacted DHCD and said, look, we've tried for months and months and months. And you just heard their presentation from there. So I just thought I'd kind of fill in that we really have tried. We were really optimistic when we negotiated this, and we supported the drive-through at the BMCA hearing, and they have just let us down over and over again. And now you can see they let the city of Baltimore down. And so we joined DHCD in requesting revocation. And we do have a couple other folks, Lina Ayers, who lives closer. We had many, this is very close to many homes in Radnor Winston. So Lina Ayers is one of them, and she can speak next.
Okay, so then I'll go ahead and make.
One question for Mr. Pontius. What you mentioned that the drive-through came online. When did it open up, if you recall?
I think it opened up right before the pandemic. I mean, they
spring of 2020.
I seem to remember that it was open the hearing was December 3rd. I think it was open in January or February at the latest. It was open before the pandemic. Because I remember thinking when everything closed down and you couldn't go into a restaurant anymore, I remember thinking, wow, those guys are really glad they got a drive-through.
Got it. Okay, thank you so much.
And if maybe I could just, so Lina Ayers was involved in the McDonald's process and also has a better sense of what they haven't done. Michael on Rossiter, Michael James on Rossiter has been documenting the middle of the night deliveries, which are still happening. And Drew Schmidt-Perkins also can talk a little bit about her outreach to the Popeyes folks.
Okay, so we'll then proceed to Lina, Michael, and then Drew.
Great, thank you.
All right. So I'm gonna, Dan, I'm gonna go ahead and mute you, and I'll keep you here just in case, but I'll go ahead and mute you, and then we'll move Lina to a panelist. Okay, Ms. Ayers, you are unmuted.
Okay, am I muted at this point?
We can see you and hear you.
Okay, wonderful. Thank you. And I thank you, Mr. McGinnis, for your very thorough investigation. And also thank the board for listening to us. This has been a source of a lot of frustration for the neighborhood. I've been a member of the neighborhood for 35 years, and I was part of the community group that negotiated with McDonald's for their when they tore down their building and built a new building. And I actually learned a lot through that process of about landscaping and how landscaping enhances a business, also how certain plants are good homes for rats and some that are not, and also how to really do how to be involved with the business. McDonald's has been a very responsive. They completely complied with their landscape plan. They actually developed their plan and they implemented their plan. Then we started working with Popeyes, and I'll say that we worked with their landscape committee. This wasn't we didn't do a landscape plan. We talked with them about it. We met with them at least 3 or 4 times, and they also had their landscape designer present at the BMZA hearing. And we really went through it very, very meticulously and tried to develop a plan that both would be not conducive to rats, as well as being positive for the neighborhood, positive for native plants, positive for pollinator gardens. One of the things that I do is that I maintain a flower garden that runs the entire width of the back of this property on the other side of the fence. And so I'm up there a lot. I see what goes on a lot. And there's others that are also there frequently. So this is not something that every once in a while somebody walks by it. The community is very involved with that property. And so the only thing that I would say about Mr. Fox's presentation is that the community didn't submit the landscape plan. That came from Popeyes. So that was their plan that they had negotiated with us, of course, and we changed a lot of the plants. But it was so disheartening when they really did nothing. And I just draw your attention to the MOU, which I believe was attachment 1 that Mr. Fox presented from Mr. McGinnis. And of the 18 things that are really outlined on that MOU, the Popeyes did 3 of them. So 84% of what they did, or 84% they did not do, I should say. And it really speaks to, is it meaningful for the community to be involved with these BMZA hearings and arrange for MOUs if the business is not going to respond and not going to do really the majority of what they agreed to do with the community. I visited up there right before the hearing started, or about 12 o'clock, and it is just a mess. There is trash everywhere. Yesterday there were car parts on part of the back. I mean, it just is, it's a mess. And so I respectfully request that you revoke their conditional use. Thank you.
Thank you, ma'am.
Okay. And now we'll move to Michael James. Mr. James, I'll make you a panelist as well. And you are now unmuted.
Okay. Okay. Good afternoon. I'd like to thank the panel this time to voice my disgust, unfortunately, with Popeyes. I live directly at 4 houses that are practically directly behind Popeyes. So we're within about maybe 400 to 450 feet. They started having deliveries usually during the daytime, and the crew would help. After that, they started having trucks coming. So I'm in where my main bedroom is, where my wife and I sleep at. It's toward the back of the house, and I hear this banging noise. I didn't know what it was, and I looked out the window and I started seeing these trucks. Sometimes they would be 18-wheelers. Sometimes they would be like large delivery trucks, and the noise was constant. Now, the trash, for some reason, when they would do the trash, would come during the daytime, during business hours. Once they started with getting, I thought getting themselves together, it stopped for like maybe a week, and then it started back up again. Just this past Sunday, I had 2 trucks come, one at 2:20 in the morning, the other one at 3:15 in the morning, making noise. And, when they open the doors up, they drop the cargo that they have. There's no one there from Popeyes to let them in. They have a key. They open up the rear door, go in, carry their deliveries. And the deliveries usually last about 20 to 25 minutes each. And it has been really aggravating with the noise, especially when you're trying to sleep. And my wife, I'm retired, but my wife gets up at 5:30 in the morning, and if that's going on at 2 o'clock and 3 o'clock, you can understand just the noise that's going on. I took photographs. I went over and took photographs of the trucks, and at the time I was having problem with my email, and I sent those to Anik, and Anik has those, but I do have them on my laptop of the trucks that were unloading, and that was the biggest thing. But I appreciate you listening to me. I'd like to thank Mr. McGinnis and Mr. Fox, and if there's anything that can be done, if they made the deliveries during the daytime, I would appreciate it, but not at 2 and 3 o'clock in the morning. And I've read also the noise ordinance, and there is a time for that with the noise ordinance that they have to abide by, or there's fines in reference to this. So thank you very much.
Okay, and then Ms. Drew Schmidt Perkins, I'll make her a panelist as well. Where are you? There you are. Okay, you're unmuted. There we go.
Thank you very much. Drew Schmidt Perkins, member of the Radnor Winston Neighborhood Association, and that terrible handwriting on the MOU was mine as we negotiated the final issues. I just want to add a couple of points. We have reached out again and again to Popeyes and have almost always never heard back from them, except for once when they agreed to meet with us and learn for the first time about this land use plan. And we were like, well, wait a minute, this was negotiated. So we handed them a hand copy of it. And after that, we've also made sure to send them copies of it and other communication. Like the city, we've almost never gotten any kind of responses. And, including when the trash is piled up, when there's been dead trees, all sorts of other problems. So it's been frustrating. And I want to echo what Dan Pania said. We were not happy about a drive-through in our neighborhood. We don't think that's good policy. But we agreed to do this for our business neighbor. and to come out with what we were hoping would be a win-win for everybody. And we're pleased that they had business during the pandemic. That was so wonderful to see. And then we've been treated like dirt since. So we support the revocation, sadly, but we do believe that that has to be done in this case because it's been such an egregious situation for us and for the city. Thank you.
Katie, you're
You're
muted.
muted.
It just is, Mr. Pontius, is this it for community testimony that you know of? I do see we have some other people here on the call.
Yeah, I think there are other people who are interested and are here as much as possible, but Peter Conrad has been your main contact, and he's on a kind of an iffy phone connection. And I think we've made all our points anyway. I mean, I think that just to think, I mean, it just seems like Popeyes is really testing the idea that they can agree to whatever, and then when they get their drive-through, they don't have to do much of any of it. And I just hope that the board, you know, I hope there's some accountability. I mean, we spent a lot of time negotiating this MOU. We really hope there's some accountability for a business, and I think it would be a good lesson for businesses to learn that when you sign an MOU like this, you need to really do the things.
One quick question, Mr. Pontius. The gentleman, Mr. James, mentioned the deliveries in the middle of the night. Is that one of the conditions on the MOU, when those deliveries be made?
I believe it was. I believe Mr. Fox kind of scrolled down. I think it was up at the top, although
It's number 5.
Yeah,
It was one of
although
them.
it's also city code, right? I mean, you're regardless of the MOU, they're not supposed to be doing middle of the night deliveries.
The MOU says Popeyes will restrict all truck deliveries and garbage dumpster removal to the hours between 7 a.m. and 10 p.m. as required by the city standards.
Right.
It's number 3.
Right.
Thank you.
Okay. So that's it. Go ahead.
This is a good time for a little break. I had a little emergency I need to go check on, about the size of a 1-year-old.
Sure.
Sure.
Yeah.
That'll give me an opportunity to find and see if there's a representative from Popeyes here on the line.
Very well.
Okay. 5-10 minutes is good. I should be okay.
Thanks. Go ahead.
All right. So thank you all. So I'm gonna give you guys all the boot from being a panelist, but please stay on just in case we need to call you back once we get Popeyes here. Thank you. All right, so even though we are in a break, we have no call-in users. So I'm going to go through the list of people who I think might still be here for as Popeyes. And there's the only 2 people here that I'm unsure of. So Mr. Wells, I've just unmuted you. Are you here representing Popeyes? Nope. All right, I have one other person. Mr. Lampretti, are you here representing Popeyes?
No.
Okay. All right, we do not have anybody here from Popeyes. Now I will say that Roxana put in the chat that the representative for, hold on, let me find it. I guess we received either a call or an email from the representative for this particular matter, and he was at the building, and she explained to him that it was a virtual hearing. This was at 1:50. And he said he would be joining soon. So there are no hand raised. There's no one. Oh, that's you, Dan. Never mind. I see the hand raised. And there's nothing in the chat as anybody here representing Popeyes, and there's no one left on the call-in users. So we, let's see.
So that individual showed up at the BMZA office, or
According to Roxana, showed up at, yeah, actually, Roxana, let me see. Are you on here? Roxana, I'm gonna unmute you. Roxana, did you have a conversation with the gentleman? I don't know if she can hear us. That was just what was in the chat. All right, she might not be able to hear us.
So who was this guy? Was he a local representative or a regional?
No idea. It just said apparently someone representing, and you'll notice that like in the letter that I sent on behalf of the BMZA, it we sent it also to the original representative for Popeyes who represented them before the board. It was Alicia Hertzmark, with the engineering firm that does a lot of this work,
Right.
and we didn't get a response from them either.
From the engineering firm.
Correct.
Gotcha.
Which, if they're not getting paid anymore,
Yeah.
and they're not, they're not under any kind of obligation to represent them.
right? None of the notices. I don't think there's a requirement, certainly, but none of the notices went to Ms. Hertzmark. Council.
Let's see. Oh, according to Mr. French, Ms. Hertzmark no longer works at CMR, but it should have, like, everything went to whoever the applicant was at that time. I would hope that they would open her mail.
Katie, I imagine that maybe we could deal with this in liberation, but just question if the authority, if the grant of the uses revoked, just file a new application to do it all over again.
Yeah, they could resubmit. So if the board took that, that's interesting. Let me get my code section for a minute. And Mr. French, maybe you can chime in on this. So if the board were to revoke, like normally when we deny something, you have to wait a year to reapply. I don't think that that necessarily applies to our revocation, because this is a section of the zoning code that this is the first time that I know of that the zoning administrator has referred an enforcement action for a conditional use before the board. So this is a little bit of uncharted territory for us here. I don't think there's anything in the code that says that they couldn't reapply again, if it were to be revoked.
Okay.
Or any kind of time limit on that.
Okay, that was also my question. I thought it was a year, but you're saying it's different when it's okay.
Yeah, I think it's different. So when someone comes in with an application and we deny it, then they can't reapply for that exact same use for another year. Let me get my code out of the other office. I'm just gonna see if there's a section I'm missing. Wrong book. Sit tight. So section 5-205 says reapplication waiting period. So within 1 year after an application for a variance or conditional use has been denied, the same application for the same property may not be reviewed or heard unless substantial new evidence is available. Submission within 1 year. So the zoning application is resubmitted for the same property within 1 year. The subsequent application must include detailed description of how the application is substantially different. This is within 1 year, or request how new evidence justifies its consideration. Zoning administrator must determine whether the subsequent application is substantially different, request, or present substantial new evidence that justifies its consideration. So I guess even if the board were to consider this a reapplication, there is some discretion for resubmitting within 1 year if there's new evidence that justifies the reconsideration. I don't believe that, so if we go to this 5-4, where is it, the revocation section?
409.
Yeah, 5-409. So whenever, and this is basically the process, and it talks about what the zoning administrator's actions have to do, what the proposed action is, what the contents of the notice, and then the referral to the board. So if the violation is not corrected within time specified, the zoning administrator must forward the record of this matter to the Board of Municipal Zoning Appeals and request the board schedule a hearing. Upon receipt, the board must promptly schedule the matter for a hearing to be held as soon as practicable, and then it only goes into decision. It says, if after notice to the parties and an opportunity to be heard, the Board of Municipal Zoning Appeals finds that a condition, restriction, or limitation imposed under this subtitle has been violated, the board may take any one or combination of the following actions: revoke the conditional use, suspend the conditional use subject to the completion of corrective action or other conditions set forth by the board, or affirm the conditional use subject to a schedule for corrective action within or with provisions for automatic termination if the schedule is not met. Board's findings must be specifically documented in the record, and that's it. So like, it doesn't say the revocation equates to a reapplication. I mean, I think potentially you could make that connection, even if you say that, essentially you've denied their application. There is something in here that they could submit saying that they have substantial new evidence that justifies the board's reconsideration.
They also could probably just submit a motion for reconsideration the way we always do. If they have some kind of evidence that they want to present, people can always ask for reconsideration within 10 days.
That's true.
That this will.
That's true with the revocation also.
Yeah, every final decision of the board, you can file a motion for reconsideration.
Okay.
And that
So like I said, this is new territory for us.
That date runs from the date of the formal. So we're trying to.
The date of the written decision, 10 days from the date of the written decision.
All right, I'm here, but I'm joined by a friend.
Yeah, who's that guy?
Hey,
little man.
Definitely not the very small person I gave birth to a year ago. I don't know who this giant is.
Yes.
But I will be relieved in a couple minutes, so I think.
All right, so we've just gone through, I'm looking to see if anyone else has joined. No, it's the same group of us. We don't have anyone here from Popeyes.
Well, that says a lot, doesn't it?
Certainly does.
Definitely.
All right, well that's it.
And so
So I guess
again,
there's-
our regs require that obviously DHD would give notice to whom it should be giving notice, obviously on site. The posting, which is always a cure-all for any other type of notice.
do you want me to have Mr. McGinnis and Mr. Fox back on and you can talk about notice?
I would prefer that to make the record clear that notice
Sure.
is required was given.
All right, so Mr. Fox, I'm making you a panelist again, and Mr. McGinnis, where are you? There you are. I'm making you a panelist again. So if you guys can go ahead and should be able to unmute yourselves. See, Greg, I just unmuted you.
Thank you. I can have Mr. McGinnis testify, especially with regard to the letter. And actually, Ms. Mayor, should I reshare the screen to pull up the exhibit again? Would that be helpful?
Sure, I think so. And then, and it sounds like the board needs to hear, are these the right people and how did they get the information?
Sure.
Let me pull up my notes here. Right. Okay, so basically to find the proper service for the owner, I ran the property through SSTAT, and during the process of my investigation, I found the property has a primary address of 2 State Road 27, number 304 in Edison, New Jersey. This is also the mailing address for, I believe it's called Parikh Enterprises, something along the line. Ashish Parikh is the authorized member, and I found multiple web searches online detailing where he actually purchases Popeyes franchises. This is one of his big businesses. When I went through my records, dealing directly with service, I do see that on 11/29/2021, a certified mail receipt was signed by an A. Parikh at the New Jersey address. So they have been properly served. They are fully notified through their resident agent in Windsor Mill, through the actual business location, as well as their headquarters out of New Jersey.
And Ms. McGinnis, on exhibit, I believe this is number 6A here, those 4 addresses at the top, when you send those out, do they get sent out first class and certified mail to all those addresses?
Yes, sir. They go out first class and certified mail to each one.
Okay. And same with at the bottom here who was copied. Is it the same thing for those as well?
That is correct. I believe all were sent via first class and certified mail.
Okay, and just scrolling back up here, so this was the address that you found during your research of who would be the authorized member as the first one. The second one here, is that the resident agent on SSTAT at the time you sent the letter?
Correct. That is the Popeyes on North Rolling Roll in Baltimore County. That is.
And is this the address? Sure, and the address here, that's the property address. You sent it to the actual Popeyes as well.
Correct.
And then Ms. Hertzmark was the original applicant, right?
Correct.
Okay, thank you.
And let me ask one question, Mr. I'm sorry, the signed receipt that you received back from apparently the resident agent.
Yes.
Is that made a part of your submission in this case?
It is in the chip log. I don't believe it is in the, it wasn't introduced as a piece of evidence, but it is in our chip log.
I'm happy to pull it up if you'd like to see the certified receipt.
Yeah, just for the record, I actually want to make that a part of the record. It'd be better if we could actually see
Okay.
So here is one to the State Road, to State Road address signed for by Mr. Ashish on.
We can't see it, Greg. You're still screen sharing your other exhibits.
Yes. I forgot I have to share a different one. Let me try that app.
Oh, there you go.
Got it.
That's it.
Mm-hmm.
And then there's also another certified receipt that had one of those COVID-19 signatures on it, not a person, but sent to the Rolling Road address. And that's also where Mr. McCann hand delivered it and talked to the gentleman at that address, which is their corporate address.
That is correct.
Very well, thank you. Appreciate that.
All right, so I'll take the ball back.
And is that it for this matter?
I believe so. So since we do not have a representative from Popeyes, like I think the normal, and again, this is the first time we've had one of these things through. I think the burden is on first DHCD to make sure that the zoning administrator followed the process and present that evidence, and then the community, and then we would normally hear from the property owner.
Sure.
But they're not on. So I think that was, I think we've heard from everybody that is here on this.
Okay. All right. Well, that will conclude the presentation for this matter, 2020.
So it's 2019 400? Is that?
2019 400, right?
Yeah.
Okay. All right. Thank you. We'll take that up in the deliberation portion, which we'll get to momentarily. Thank you, gentlemen.
I already threw them out.
Okay. So, before we get to, we probably discussed this last one for sure. Are there others that folks wish to discuss or?
I think from my notes, everything is either postponed or on consent docket except for 3 of them. So 2021-349, which was 466 Hornell, and then 2021-355, which was the Park Avenue case that we just did, and then 2019-400,
Right.
the Popeyes. So I think those are the only 3 that we need to deliberate on, or that you need to deliberate on.
Those 3? What was the first of those?
Was 2021-349.
Yeah, I mean, they implicitly agreed to, just put the barbershop
Oh, gotcha.
on the basement floor, but not the. Well, I guess there's still a vote required on the 2 dwelling units.
On the 1 dwelling unit. Well, yeah, it's more of a vote on the conditional use, right, Katie, on that one?
Right, because she understood that she can only have 1 dwelling unit, but
Right.
At the time she applied, she didn't realize that. So I think the only thing that the board can vote on is the conditional use.
For neighborhood commercial.
Correct.
Yeah.
For the
Okay.
barbershop.
So we don't need to say because the application reflects 2 dwelling units that she was seeking, we don't need.
Right, the only thing the board's gonna decide on is the conditional use for neighborhood commercial at the barber shop.
I mean, Katie, I was wondering, should we have the board vote no on the 2 dwelling units?
That's what I wrote in my notes here.
Okay, yeah, well, yeah,
I think the application.
yeah, we can definitely do that. She already understands that she has to go to the city council, so I think probably a no vote would help her, you know, as far as going to the conversion too.
Right.
Okay.
The Park Avenue, Ms. lengthy letter, I did look at that lengthy letter again with all those issues. I think, I don't know, I think Mr. Caballo satisfied those issues. I know any thoughts from the board on 355?
No, I agree with you, James.
And just a reminder, the only issue before the board on Park is the 10-foot setback, rear yard setback, but the photographs show the existing garage is right on the property line now. So the demolition of that is what's causing the requirement for a reapplication of the 10-foot setback because it's a new building, right? So like if they were to have maintained that structure and built up, they would have probably needed the setback for the upper floors, but not for the first floor. And then it's the off-street parking is they're providing 2 spaces, so it's a 6-space variance for parking. So it's rear yard setback, 6-space variance for parking. Those are the only 2 issues before the board on Park.
And those are evaluated under the variance standards. So we have to think about in terms of the uniqueness of the parcel, making it a hardship for someone to provide the parking and to abide by the setback. And I
think
can
he
pull up
also said,
those. Oh, sorry.
I think he also said that they only have 3 parking spaces presently.
So, yeah, they definitely have some. And yeah, so I guess what other factors that Mr. Carbello stated would you guys find meets the hardship and the uniqueness of the property standard?
Well, I think the original footprint of the building, it was built to the end of the property line. So there's 0 setback there for the building as is. I have in my notes here, they're not complete, but there was not space to provide. There's not physical space there to provide parking.
All right, so just summarizing, you've said the construction of the original building, the original garage, as far as that it didn't have a setback, and the lot is fully developed now as it is. And even if they demolish this and reinstate what that original footprint is, there's no space for parking.
Right, that's my takeaway from the evidence.
Okay. Great.
There's no more discussion on that. We can talk about this drive-through for Popeyes. I guess, you know, given the research that we understand is the case for a revocation, that would not be restricted in moving for reconsideration of that ruling, and I guess also for maybe some other considerations down the road, but it don't need to wait a year to come back.
I don't think that they would. And like I said, even if that were the case, there is there is a
Hmm.
there's a thing in that section that allows you to come back within a year if
Within a year.
circumstances have changed. So, you know, for example, if they
got
went
trash
ahead and
cans, we got
actually did what
signs.
they were supposed to do, right?
Yeah. Um, so I think they've been given every opportunity to apply. I think the notice is appropriate. It appears and valid, and they even sent it to other folks that weren't required to get it that might help get to the true owner who could do something about it. Even the manager on site, apparently, according to the testimony, was given paperwork and indicated that he sent the screen and somehow got no response from individuals, and we don't have anybody here today. I think the notice indicated, or I guess, where's the posting for this hearing for that project? Was it at the site?
It was.
Okay. Okay. It's a virtual hearing. Somebody contacted, and we know about this now. Somebody contacted the office allegedly at 1:50
Mhm.
this afternoon. It's 4:00. Yeah, there's certainly better part of another hour at least. We were hearing this case, and I haven't heard from anybody from Popeyes, which is consistent, fortunately, with how they've operated on this paper. One of the things I was considering is, a suspension until they apply. There are a number of things to do. The violation notice identified 4 things from the HCD, but I think that didn't even include the other things, which, according to the testimony, are also violate the condition, which is the deliveries in the middle of the night. It violates noise ordinances.
Can I pipe in here, James?
Say again?
Can I pipe in here?
Yeah, absolutely. Go ahead, Bill.
First, I'm really impressed with the investigative work that the city did in this whole thing, particularly Mr. McGinnis. And I think we all know just how vigilant a neighborhood Radnor Winston is when it comes to items like this. And if we were voting right now, I'd vote for revocation to send these guys a wake-up call.
Yeah, that's where I'm heading. I mean, because also that the suspension, a suspension pending certain things to occur. I mean, they could, for example, take the initiative. How long does it take to get trash cans there or put signs up? I granted, landscaping may take a little bit longer, but you could still put in things that you need to do. And whether or not they'd be complying with the non-deliveries in the middle of the night would probably take some time to see. So I think they need to be demonstrating that they do all the things that they're required to do, and then come back and however they want to do it through via motion for reconsideration or some other way, demonstrate that they have earned a right to be reconsidered for the drive-through. I mean, it's a real disservice to. Go ahead, Sabrina.
I'm in favor of revocation as well, but I have 2 follow-up questions.
Sure.
Probably more, but 2 I can think of right now for everyone. The first is, when does it become, like, if we revoke it right now, when does it become enforceable? Like, when do they have to cease? And it's just cease drive-through operations, right? It's not cease the
Right.
whole restaurant.
Correct.
When does it take effect?
So you can make that determination. So obviously it's not going to happen until we write a resolution. So you can say 10 days after the date of this resolution. You can say immediately upon the date of this resolution. So I think there's flexibility there for the board to identify when the revocation would take place.
Okay. My next question is, what if they don't what if they don't stop the drive-through? What if they just keep it open?
That becomes an enforcement issue for DHCD because this is an order issued by BMZA, which then becomes part and parcel of the permit record. Then the Department of Housing, and it's a zoning violation. So a special investigative unit is charged with enforcing the zoning violation. So if they fail to comply with the terms and they stop operating, then, or they don't stop operating, then DHCD would go out, issue them a notice, issue them additional citations. And if Mr. Fox or, other attorneys, this is actually Simon, I don't, it might be Simon or Mr. Fox, I don't know, one of the,
Aaron Simon.
you heard, it might be Simon, I can't remember whose district this is. They would actually file an injunction in district court for a violation of the board's order to cease and,
Now-
for the revocation.
What happens if they cease operating the drive-through? Like they're supposed to, even though nothing suggests that they will, given that they haven't responded to anything that DHCD has said to them so far, the owner. What happens if nothing else changes? Like what happens if the deliveries still come in the middle of the night and everything that's wrong with it stays wrong with this Popeyes? Because I know it existed for years without a drive-through. They only had a drive-through for a year and a half.
So I think then that becomes another enforcement issue for DHCD. So then they would probably look at actual violations of code. So if there's a law that exists that says you can't have violations in the middle of the night, then they could file and issue a notice specifically for that and file an injunction specifically for that in order to get that to stop.
Yeah, because the MOU only applies to the drive-through. If they don't have the drive-through condition anymore, then the MOU conditions that are not already in city code don't really apply. So like the landscaping
Correct.
stuff wouldn't be relevant anymore.
Yep.
But the things that are already violations would still be violations.
Right. So DHCD could still sue them under city code violations, property maintenance code violations. I think noise falls under health, if I'm not mistaken. So all of those things could still be enforced. All city codes could still be enforced if they chose to stop using the drive-through and do nothing.
Okay.
That was also my question, the
Okay.
same question that Sabrina just asked. But in addition to that, one other thing, there wouldn't be a different, or maybe there would be a different level of enforcement between if we decided to revoke, whether to suspend. I'm assuming it will be the same process, but maybe will it go faster if we were to revoke? Or will it be more of a signal to show that we are more serious if we revoke, whether to suspend? I don't know.
Yeah, I think the issue of suspending then has us identifying conditions pursuant to which that suspension maybe could be lifted, or if we say suspended until 1, 2, 3, 4, 5, the things that have been identified have been remedied. We have the conditions by the DHCD, those 4 enumerated items that have been identified. But again, we have the additional violations, those conditions that were offered in testimony by the residents. I think
Could we
if
say,
we simply,
could we say something like suspended until these things are met and you have a redraft the MOU with the, because they have to have a meeting with the same people they made an agreement with, because they didn't really make an agreement with us necessarily. I think that is there a way that we can do that?
yeah, I think at this point the onus really needs to be on the Popeyes to do what it was supposed to do and figure out what that is. I don't think there's any validity or merit in their agreements. They didn't honor them, and let them decide what it is they need to do. But clearly, the violations have been established, and I think the biggest notice to them, the biggest volley that we could give to them is a revocation period, and there are mechanisms for you to fix that.
Right, and
But you need to fix all of it.
Yeah, just to remind the board now, the things that Mr. McGinnis identified, those are things that he based off of his own observation. But Mr.
Sure.
James testified to the noise, Mr. James testified to the late night. deliveries, which Mr. McGinnis didn't observe directly. I think it was Ms. Ayers that said, 18 of those points in the
Only
really
three things
detailed.
that they did.
Yeah, they only did 3. So, the board could specify that all, if you revoke, you basically can say, we find that you've failed to comply with,
Yeah, A, B, C, D, and E. Right.
these kinds of things, and you're revoked as of X date. And then it's on them to decide if they're gonna reapply, file a motion for reconsideration, do something like that. Either
Yeah, and
way,
then-
I think DHCD would go out and take enforcement action if they continue to operate that drive-through after the revocation.
Yeah. So yeah, I think a revocation is cleaner and more definitive. And again, it requires Popeyes to step up and do all the things that it's required to do in order to, in whatever form they choose, to come back and say, we've done these things, we've complied, or we've reached out to the community and we've agreed to modify X. It's not likely, but they could do that. But in any event, it puts the onus on Popeyes to do far, far more than what it's done.
Once again, I agree.
So, all right. Well, I think if there's no more discussion, we can just go to the vote. Everybody ready for that?
Yes.
Sure.
Okay.
Yes.
Ready
All
to
right. So
go.
let's go with, guess got to read from the top. Case number 2021-282, 921 North Crescent Street by consent. Case number 2021-283, 923 North Crescent Street by consent. Case number 2021-313, 2623 through 2627 Washington Boulevard is postponed. Number 2021-321, 3401 Minnesota Avenue by consent. Case number 2021-333, 428 South Bentaloo Street. I am no.
That's right. Yeah, she kind of said, okay, thank you, and left.
Yeah.
That
Yeah,
was the
I should check it
non-conforming
out.
tavern expansion. I forgot about that one.
Yeah, the only request is to go to the second floor for the tavern and can't do that. I'm a no.
Yeah, I'm a no.
No.
Rest of the votes?
Yeah, Leland Otis.
No.
Already, oh,
Okay.
Okay, we have all that? All
I
right.
think so. I think we got no's from everybody.
Okay, 2021-341, 124 Marketplace. Is by consent. Okay, with conditions that were agreed to, it's on the record. 2021-342, 4114 Montana Avenue is by consent. 2021-343, 808 South Ann Street is postponed. 2021-345, 2127 St. Paul Street is by consent. 2021-347, 1639 Belt Street is by consent. 2021-348, east side of South Haven Street, O'Donnell Street is by consent. 2021-349, 466 Cornell Street. I'm a no as to the request for 2 dwelling units, and a yes as to the conditional use barber shop.
I'm the same.
I'm the same.
Same.
Okay. Everyone?
I think so. Leland, did you chime in yet? Did we lose Leland?
Did we lose?
Sorry, yes, I
Okay,
did.
thanks.
Okay, gotcha. Thanks, Lou. All right, where am I? 2021-351, 301 East 24th Street. It's by consent. 2021-352, 2411 Taney Road. I guess that's consent. We go to Why am I remembering that? It's something
Yeah,
else.
no, remember that's the guy that chimed in at the end because he was unsure how
Right.
the layout
But it
was,
was in
and
the-
then when he
but it
saw
was in the
it, he was
with.
okay. Mhm.
Then you're
Yeah.
okay.
All right. Well, I'm a yes. If it's
consent, right?
It's still consent, or
Yeah,
because
so
he
I would say
raised
it's
the
still
issue?
consent because he
All
really
right.
wasn't in opposition. He just wanted to
Yeah.
know.
Wanted to confirm some information.
Right.
So, all right. 2021-354, 1127 North Caroline Street was postponed. 2021-355, 814 Park Avenue. I am a yes, given the presentation of the
yes.
evidence,
I'm a
footprint,
yes.
for the reasons that we stated previously, the footprint of the original building, as well as the testimony and demonstration and pictures of no room for parking.
I'm a yes as well. This is Otis.
This is Leland. I'm also yes.
2019-400. I vote for a revocation of the conditional use to be effective. I don't know. I'd say it 10 days after the issuance of the ruling, but only because I want to be sure they get it.
Right.
You know.
I agree.
I mean, 10 business days, 10 regular days. I'm all for drafting and having it say yesterday, but I guess if you have to send notice to New Jersey.
Yeah, that's my only issue. Let's say 10 calendar days.
How about instead of 10 days, we say an actual date? That way there's no confusion with weekends or technicalities or
Well, we don't know when
anything
the
like that.
rule. We don't know when
Yeah,
the
but
decision's
we
going to
haven't
be.
written it yet.
Oh, okay.
So it's not effective until it's written, and then.
What we could do is 10 days from the date of this resolution being X and put the actual, like, do the math and put the actual date in the resolution. We can do that.
Okay.
I'm all for clarity.
Yep.
And if we're gonna, and it's gonna be calendar days, right?
Yeah, I would say calendar
Yes.
days.
Okay.
Right. And 2022-125, 2703
Could we,
through.
I don't know if I heard the full vote for
maybe,
the York Road one. I think I heard 3 people.
Yes, Otis also votes for revocation as well.
Okay.
Leland, you're the same?
Yes.
All right.
Excellent.
2022. Sure. Sorry, Becky. 2022-125, 2703 through 2709 Foster Avenue. It's by consent.
Right.
Right.
All right. I think that's it.
That was really interesting. I've never seen anything like that before.
Yeah.
Well, get ready because
Breaking the
I'm
ground.
feeling, we've done it once. We're gonna see more revocations coming our way.
Yeah.
Okay.
Yeah. Well, they did it the right way. I mean, they followed all the rules, and
Yeah.
Really good.
we have to do
All
it.
right.
Yeah. So, all right. Thanks, everyone.
All right. Thank
See
you.
ya. All right.
Bye,
Thanks.
everyone.
Bye.